agenda meeting, okay.
All right. Good evening, everybody. My name is Jeff Thoman. I'm the chairman of the Fair Rent Commission. I'd like to call to order the December 11th, 2023 meeting of the Rock Hill Fair Rent Commission. With that being said, we're going to waive the approval of minutes. I also wanted to discuss briefly with regard to our commission's function here today as a Fair Rent Commission pursuant to statutory authority. Fair Rent Commissions consider a number of factors when determining whether a rental charge is excessive to the point of being harsh and unconscionable. The factors that this commission considers as applicable to the individual cases include rents changed for the number of rooms in other housing. The rents charged for the number of rooms in other housing accommodations the same and in other areas of the municipality, the sanitary conditions existing in the housing accommodations in question, the number of bathtubs or showers, flush waste closets, kitchen sinks, and lavatory basins available to the occupants, for the services, furniture, furnishings, and equipment supplied therein. 5, the size and number of bedrooms contained therein. 6, repairs necessary to make such accommodations reasonably livable for the occupants accommodated therein. 7, the amount of taxes and overhead expenses thereof. 8, whether the accommodations are in compliance with ordinances and the general statutes of the state of Connecticut relating to health and safety. 9, the income of the petitioner and the availability of accommodations. 10, the availability of utilities. 11, damages done to the premises by the tenant caused by other than ordinary wear and tear. 12, the amount and frequency of increases in rental charges. And 13, whether and the extent to which the income from an increase in rental charges has been or will be reinvested in improvements to the accommodations. Please note that nothing in these statutory criteria shall preclude the commission itself from considering other relevant circumstances. That being said, the procedure tonight, as stated in the notices that have been sent out previously, evidence concerning evidence that this commission has reviewed include the complaint and any of the supporting documents. We've also had it announced as a procedure in prior notices that evidence from all parties must be submitted to the Human Services Department no later than 7 business days prior to the hearing. Evidence containing more than 5 single-sided pages will not be allowed to be submitted at the time of the hearing, that being tonight. That had been previously announced and set forth. So I understand as part of the materials that we've received, we received a notice asking from concierge attorneys to asking me to recuse myself. Attorney Slater, if you could advise on that.
Sure. As a representative on a commission, you need, in order to be seated, you shouldn't have a personal or financial interest in the matter, and that includes, a perceived one. If the general, if you have a, you might have one description I give you. You might have your best longtime friend who's an applicant before this commission. You may, in your heart of hearts, believe that you're going to be fair, if not maybe even more tough on that person than a general member of the public. From the public's perspective, you'd not be perceived to be unbiased there. So each member, as the commission at any given evening, even if not called upon to recuse themselves, need to assure themselves that they don't have a personal and financial interest. The other thing is they can't be prejudiced in a matter. They have to, to the extent you're holding a hearing and you're going to be hearing from both sides, you need to be comfortable that you will listen to that evidence and this public hearing isn't essentially a sham, that you haven't made up your mind. One other thing I would want to point out, though, that this agency is not, sometimes an agency acts, sometimes it's called a quasi-judicial capacity, where basically you have two opposing parties and they present information and you are supposed to weigh the information and make a decision about that. The Fair Rent Commission is different. It's an investigatory body. It gets powers to do investigations. Frankly, you all could go meet with a complainant, walk in their house, walk in their apartment, review everything, prepare your own reports. There's no specific procedures in the statutes that tell you exactly how to do your business, but one element that's contained in the request to recuse himself is concerns that the chairman has been leading witnesses and asking questions. You can all ask questions of a witness to try to draw out facts. It's not a matter of just like there's two adversaries that are presenting the information. So I would advise you that, unlike situations where you're essentially acting like a judge, where there's two parties that are warring before you and you have to decide, you have a responsibility to try to get to all of the facts that you can get related to the complaint in order to enable the commission to make a decision. So based on that, you and only you can make the determination of whether you are qualified to serve as a member of the commission on the matters that there's been a request that you recuse yourself.
Okay, and I've had I appreciate that, and I've had an opportunity to review the letter as well as documents that were attached there too, submitted by Robinson and Cole on behalf of Concierge, requesting that relief. And at this time, I want to state for the record that believe that I'm going to be impartial. I am impartial with respect to my review of these complaints. Each and every case is its own individual complaint. There's been complaints that I've ruled in favor of Concierge. There's been complaints that I've ruled against Concierge and in favor of the tenants. Each and every one is on their own merits. That being said, I believe I am impartial, and I can continue to be so with regard to the 4 cases that are listed on the agenda tonight, and therefore I will not be recusing myself. Okay. That being said, I want to make mention again with regard to the procedure as we proceed in order for new business. We're going to be taking this in order of the cases, beginning with case number 2023-01, Kristen Cheney, 200 Cold Spring Road, Unit B302. There initially, again, in our initial notice for this agenda item and these cases on the agenda was sent out via certified mail on October 30th. There's been several requests for various reasons for an adjournment of the hearing on that date. Originally was scheduled for November 13th. But what I wanted to make note is included in that original notice, and I know that counsel for Concierge and the other parties have also communicated directly with the town attorney about accommodating schedules and moving those dates. As part of that notice that was sent out certified mail, that initial notice indicated again that the evidence from all parties must be submitted to the Human Services Department no later than 7 business days prior to the hearing. Evidence containing more than 5 single-sided pages will not be allowed to be submitted at the time of the hearing. So I have received packets from both sides, the initial packet as well as the supplemental materials from the tenant. I also note that we received a packet from Concierge submitted on December 4th, though not necessarily 7 business days but before the hearing. I'm going to allow it. I also found out that sometime about close to 5 o'clock on Friday, some additional materials were submitted to the commission, which are well beyond the deadline set forth in the initial notice and the subsequent notices for this hearing. So I'm not going to entertain that evidence. We have rules of fairness that apply to both parties. That would apply to the tenants as well.
Oh, okay.
Those rules apply to both sides, and each side is entitled to understand what the other side is submitting in terms of evidence, what their claims are, and what their defenses are. So just as the rules would apply to concierge, they so too apply to the tenant. It's just principles of underlying for fairness. We also have to understand that the commissioners are here are volunteering their time and expertise in deciding these cases. If we didn't have rules like this, we would be here all night, the next night, and the very next night. And we don't want to have situations where we have documents provided to the commission for the first time the night of the hearing or the morning of the hearing. In some cases, in the past, there's been documents submitted that have been in excess of a couple of hundred pages just for each complainant. And that is unfortunate, but it also it prevents this commission from functioning properly and adequately addressing in a timely manner the complaints before us. So with that said, the rules are the rules. Both sides received notice of that. I also want to point out that the first complaint from relating to case 2023-01, Kristen Cheney, I hope I'm pronouncing that correctly. My understanding is that this was filed around March 2023. I'm looking at a notice dated March 1st, 2023, that was from the town of Rocky Hill addressed to the chairman, myself, Fair Rent Commission, as well as the case landlord, in this case concierge, in which the Fair Rent Commission, noting that the Fair Rent Commission had received the attached complaint, it also attached the complaint back on March 1st, 2023, and that was sent to concierge rental office on Cold Spring Road, and advising them that the commission had received the complaint, and we had requested the landlord speak with the tenant within 15 days of receipt of the letter and complaint, an attempt to hopefully resolve that. So I wanted to clarify that because there's been some discussions in correspondence to this town indicating that for the first time that the complaints were received a few weeks ago and that concierge had no notice. So I wanted to clarify that for the record. I know that concierge and Robinson Nicole is in the position of being the third attorney law firm for concierge. This has been something that's been out there for a while in terms of procedure. When the town receives a complaint, they will send that to the commission as well as to the landlord, whoever the landlord would be. And in that case, in the case of Kristen Cheney, it was sent out on March 1st, 2023. So that being said, how we're going to proceed is you should understand, Ms. Cheney, we're going to call you up and swear you in a second with regard to your complaint. Understand this, that the commissioners have had an opportunity to review the materials you submitted. Same thing to concierge. We have reviewed the materials that were submitted in due time and timely submitted, I meant to say. And so we're familiar with the facts. While we may ask you to give a brief summary of your complaints, don't be surprised on either side if some of the commissioners either have questions and want to get to a certain area or issue and ask right away because they've prepped for this hearing, or don't be surprised because they've prepped for this hearing, they may not have any questions at all. So with that being said, if you could swear the witness.
I can do that. It sounds like
I would just like to ask one question, if I may, before we
Yeah, if you can come to the microphone, identify yourself for the record.
Ryan Hoyler, Robinson and Cole, representing Century Hills / Concierge. I just want to inquire of the commission what your rules regarding a quorum are and whether you believe you have a quorum tonight.
Well, we have five sitting members that are full-time commissioners. We have, and with that tonight, we have 3 out of 5. That's a quorum.
Okay, that's it, and I just wanted to reiterate our objections to your non-recusal. You have our letter, you understand what our points are, so thank you.
So, can you raise your right hand? State your name and address on the record.
Kristen Cheney.
And do you swear or affirm, whatever the case may be, that all the information you will give tonight is the truth, and nothing but the truth?
I swear.
Okay. Ms. Cheney, we've received your complaint, which I believe was filed back on February 27th, 2023, correct?
Yep.
Okay. And you no longer reside at 200 Cold Spring Road, Apartment 302, is that correct?
Yeah, I don't live there anymore.
Okay. And during the time that you filed your complaint, you were living there, correct?
Yes.
And based on the documents that we received, I understand that there was complaints with regard to no ventilation in the bathroom as well as suspected mold, a complaint of no hot water for 22 days, months of cockroach infestation and issues with hot water. Is that correct?
Yes.
Okay. Is there anything you can tell me with regard to your complaint about no hot water for 22 days?
It wasn't 22 days consecutively.
Total.
It was just total of. The longest span was about, I think, 5 days. And it was, I don't have the exact dates to be honest, but it was right before I filed this, and that's why I filed this complaint, because it was, I believe, 5 days without hot water, and I was honestly appalled by it, and knowing that there's children and elderly people living in that apartment complex is the reason why I pursued this.
Okay. Did you ever get any inspection done of the mold?
No, I did not.
Okay.
I did send an email to the health inspector, which is actually in my file, or the pamphlet, but they never came out to inspect it.
Okay. And I saw some of your written complaints with regard to the issues for no hot water. Do you know the reasons for it or what their response was?
They said that the boiler was down and it was tripped by wind or rain during a storm.
What were the longest consecutive set of days that you were without hot water?
I believe it was the 5 days, but it was when it reached negative 17 degrees. I don't know the exact date off the top of my head, to be honest.
And what relief are you seeking tonight?
I more or less am just trying to seek relief of the payment that I've had to do for having to pay for the expenses of the cockroach infestation. I had to spend probably about $200 for the mats, the sprays, and then I also had to pull my cat out of the apartment complex for 3 months. So I was paying $50 a month for her to live there, but she wasn't living there. So that was another thing that was an issue.
In addition to the 200, if I heard you correctly, $200 for the materials you bought to address the cockroach infestation, you had about $150 in expenses with regard to boarding the cat.
Yes.
Are you seeking any compensation with respect to the being without hot water for 22 days?
I mean, I did have to travel out of my way to my parents' house to shower multiple days for those 22 days. Those days I had to travel out of my way, so that's gas and time.
Okay. And at the time, you were paying a rent of $1,759 a month?
Yes.
Anybody have any questions? No. Okay. Ms. Cheney, I want to advise you, concierge is represented by council, obviously, as you know. As they today, they may have some questions through the way our procedure set up, although you may not have been part of this concierge council. Is the way we're handling it is that if they have a right to ask you questions as part of the defense of their case to probe and ask us questions. And what they're going to do is they're going to ask it through us.
Okay.
If it hasn't already been asked and the answer file relevant, we'll just, it may seem a little bit cumbersome, but we'll ask the question of you. So they'll pose the question through this commission, which will then ask you of it and remind you that during that process, you are under oath.
Yep.
Okay.
Are you going to allow questions now?
Yeah.
The easiest way would be if counsel, I think, takes the microphone over here, the witness can continue. You can ask the question, so you'll be on the record if you just come up here on the end of this table.
May I just use, I don't have any questions. I just want to put it on the record that I don't have any questions.
Okay, that's
No,
fine.
no need. You can just sit down. That's fine.
No questions.
No questions. Okay.
I have one question for the tenant.
Absolutely.
I have a question for you.
Yes.
You had boiling water burn you at one time?
Yeah. During the summer, the water got so hot that it wasn't like a severe burn, but it was definitely like a mild burn.
Did you let them know that you had a problem with
I called. I didn't send a complaint via the form
Okay. So you did speak to someone regarding,
on the phone. Yes.
did they
So I-
adjust the water for you? Do you know?
that I'm aware of, because I had the issue again. So
Okay.
Question just with regard to the cockroach infestation. You said that you had to put your cat up for 3 months. So am I to understand that this infestation continued for a 3-month period?
yeah,
Okay, was it consecutive months?
yeah, it was like 3 months.
Okay. And what was the response of concierge?
So they had someone come in and spray. I don't know what that person was spraying, but they were spraying something.
Okay. You said, was that the only instance in which they came to treat the
They came
cockroach?
2 times.
2 times. And the first time that they came, how soon after you first complained about it?
I think it took a while, but I don't remember how long, because I know I had to purchase my own stuff before that person came. That's why I know that I purchased stuff and then that person came, and
What about the second time around?
I honestly don't remember.
Okay, understood. Any of the commissioners have any questions? The witness?
No.
Okay. Ms. Cheney, thank you. What we're going to do next is concierge has the option of presenting their own case.
Yep.
And at that time, we'll take any evidence that they, I'm testimony or how they're going to present their case, and we'll discuss it with them. During that time, after they conclude in presenting their case, if you have questions of them as well, I would ask that you don't pose it directly to them, you pose it to the commission. You'll have an opportunity to do it just as they did for you, to cross-examine or ask questions however you see fit through the commission, and which, if we deem it appropriate, we'll ask concierge.
Okay.
All right?
All right. Thank you.
Thank you. You may sit down. Yeah, thank you very much.
Hi, again, Ryan Hoyler from Robinson and Cole. I'm just going to start off with a couple quick objections. First, I object to the statement that we were served with this complaint. During the November 14th hearing before this commission, one of the representatives of Century Hills mentioned that that is not an address at which they regularly receive. She does not, the property manager at the time did not receive mail at that address. Second, since at least September, the commission has been aware that Century Hills is represented by council. While that council may have changed, no notice was sent to to council. And finally, we made a FOIA request of the town on March 8th asking for any complaints against Century Hills that had been filed up to that point. And Ms. Cheney's complaint was not included in the response that we received, despite the fact that it had been filed, I think, 2 weeks earlier. So we do object to the concept that we received notice of this prior to October 20th. As far as we understand, the first notice we received of this complaint was October 20th, which is why some of the materials came in a bit late, because we had to collect all of this stuff. Any refusal by the commission to hear evidence from us today will be considered an appealable issue by us.
You can consider it anything you want, but the rules stated when you're supposed to submit it. You did ask for regardless of, if you don't mind, Mr. Chair.
No, absolutely.
All I was going to say, there isn't a dispute that you requested the continuance tonight, that you had notice, you sought the additional 15 days to work with the complainant.
That's correct.
Per the rules, and then you were given the continuance to tonight.
That's correct. Yeah, we do not deny that we were given a continuance to tonight, nor do we deny that the agenda we initially received for tonight, when we were given that continuance, documents, I believe 3 weeks ago, contained a deadline of 7 business days before, which would have given us approximately 8 business days total to put together any of the records we needed to put together. So again, we object to the timeline. We believe it's arbitrary. And again, any refusal to hear evidence tonight will be considered by us, as Ms. Attorney, the council's pointed out, be considered by us to be an appealable issue. So with that said, 2 of the documents that we did submit on Friday that the commission has said they will not receive, I do want to point out that one of them is and I'm happy to hand it to the council tonight, it consists of 9 pages, but it shows that the exterminators went back not twice, but 9 separate times to the apartment to clean up the cockroach issue between September and November of 2022. So I'd be happy to submit that to the commission. The other document is, among others, but these are the only 2 that I'm going to bring up now, are...
Counselor, let me ask you a question. You're an attorney. When they set rules for filing deadlines, you adhere to those rules, correct?
Absolutely. If a rule for a filing deadline gave me 7 days or 8 days to put together a case when the other side has had 9 months, I would absolutely object to that, and I would not expect that to stand. But nonetheless, we would comply with it, yes.
I didn't state where that address, I understand that it went to Cold Spring Road, that the complaint was sent. Are you stating on the record that your client denies ever receiving that complaint? I'm not asking if you received it. You're the third law firm representing concierge
Correct.
in these cases. I'm asking you, if you can state on the record, are you denying, is it your client's position the client never received the complaint from?
Our client's understanding as of today is that they did not receive this. I don't know who signed for it. And again, whether we were counsel or not, the commission was well aware that Century Hills had counsel at the time and did not send notice to that counsel. And again, I would bring up the FOIA request that we made 2 weeks after this came in, asking for any complaints made against the Century Hills because we wanted to get ahead of these types of complaints. And Ms. Cheney's complaint was not included in the response to that FOIA request.
Okay.
So again, I am happy to provide copies of the invoices for the exterminator. The other document that I'd like to show is invoices for the boiler that were done in February of 2023. It shows that in total repair costs, Century Hills spent nearly $10,000 in work to be done to the boiler, as well as nearly $100,000 purchasing a new boiler that they had to bring from Louisiana halfway across the country up to Rocky Hill. It's an old building, and this was an issue that arose. You can see from this invoice here that, again, was submitted to the commission ahead of this meeting, that there was significant work done by contractors to attempt to fix the boiler. When it became clear that the boiler was unfixable, they reached out to apparently the only place in the country that they were aware that they could get one, which was in Louisiana, and spent $100,000 to have it shipped up by truck, because it's the only way they can do it, up here. And that took more than a day.
Question that I have for you, though, is let's back it up a little bit. With regard to the cockroach infestation, do you have any evidence or anything to dispute that the cockroach infestation lasted over a 3-month period?
The evidence I have is that the cleaners that concierge paid for kept going back, primarily, I believe, in September and October, and a little bit into November as well of 2022.
Okay. Go ahead.
Yeah, I have a question. Were other tenants in the building, did they have a cockroach infestation?
I would describe it as an infestation, but there were other apartments on each of those. If you look at it, it's like September 9th, September 14th, the exterminators came back, and there are different apartments. Usually it's like the apartment above and below they want to check as well as apartments to the side. But there was more than just Miss Cheney's apartment.
Okay.
Question, you mentioned expenses for a boiler for the building. I'm assuming that this boiler that was being replaced also affected other units within concierge,
That's our understanding, yes.
and to the point that they would not have hot water as well until that got fixed.
That's our understanding, yes. And then during certain periods before the replacement, when West State Mechanical was attempting to fix the boiler, it was also off for certain periods of time as well.
Okay.
One thing, if I could, just counsel, it's obviously an informal procedure, and, you know, and you can certainly reputable counsel for concierge, but he's not a sworn witness, so you can take, you know, into account some of his statements, but it's really going to be the evidence that they've submitted that you should rely on, and not, you know, some of the, and more detailed about, you know, what kind of trucking it took to get it up there. You really need a witness to be able to identify all that. But I think for your purposes, that, you know, just wanted to
Yeah,
point that out.
I understand. I appreciate that. What I'm trying to do is just address it in a way is to sort of get to the point of, did this, the attempts and the documents you're providing to the commission you've submitted, does that address the issues that this tenant complained of?
So I don't know that our position is that this was an issue. The boiler had came up, it was a problem. They had been trying to fix it for some time. It's an old building. They spent a significant amount of money and time attempting to fix it. When the fix did not occur, they spent an even more significant amount of money to replace the boiler. So, you know, did Miss Cheney go days without hot water? It appears so, and I don't know that there's anything that concierge right now can do about that. But what we can do is show that we did our best quickly and at our great expense to us to attempt to fix this problem, and ultimately were able to remedy it. At this time, I'd like to call up Melissa Davis for just a couple brief questions. Okay. She's the property manager at Century Hills. Would it be easier if I moved over there and have her?
certainly.
Yeah, okay.
Yes, I'm sorry. Raise your right hand and state your name and address.
Melissa Davis, and my what?
Address.
98 Cold Spring Road.
And will you swear or affirm, whatever the case may be, that all the evidence you provide tonight will be the truth, the whole truth, and nothing but the truth?
Yes.
Hi, Ms. Davis. Can you explain what is your position at Concierge Apartments?
Sorry, I'm the property manager.
Okay. And what in that role, just generally, kind of what do you do?
Basically oversee the property of what's happening, daily activities at the property, collect rents and the move-ins, move-outs, so forth.
Okay. Are you aware of the boiler issue that was dealt with in the winter of 2023?
Yes, I am aware.
Can you state, to your knowledge, what was done to repair the boiler?
We had West State Mechanical comes out more than once to try to fix the boiler from, it was basically not being lit correctly. I guess with certain winds or certain rains, it was knocking out the boiler. But with many attempts, it goes on and goes off. That's when we decided to just replace the boiler.
Okay. And ultimately, you did end up paying to buy a new boiler, correct?
Yes.
Okay. Are you aware of the pest control issues in Unit B302?
Yes, I am aware.
Do you know what Concierge did to attempt to remedy that?
We contacted our vendor that we use, which is Connecticut Pest, CT Pest, to address the issues in her unit.
And do you know if they ultimately did address the issue?
Yes, their days are on Fridays, and they came on anyone that addresses it or when she addresses it, they come out on the following Friday to address the issues.
Great. I think that's all I have for right now. Hold on one second. With regards to the bathroom vents, can you explain generally how that works at Concierge?
So in our A, B, and C building, there's a main vent that's on top of the roof that pulls the air. So there's only one vent, it's not individual. In the units, it's one vent that pulls.
So just to clarify then, there's no fans in each individual unit, correct?
No,
Okay. And there is a fan on the roof, correct?
that is correct.
And that fan works?
Yes,
And you understand that it has historically worked?
yes.
Okay. That's all the questions I have. If the,
Questions?
Questions?
I have a question. I think that I heard that in terms of the infestation, that they came by 3 times, I think you said?
Nope, nope. It's, you're asking the witness, right?
I'm sorry, me?
Right. mhm.
Oh, you're
just
asking
want-
if they came 3 times?
Yeah,
I don't,
and
I don't
you-
have the records in front of me, but I do know that
I
we,
think that
I'm sorry.
somebody, I think. either
Counsel, sorry.
Counsel
Yeah, he has
said that
the
they came
documents.
by 8 times. I just
9.
want to get to 9 times, okay.
So we will have a report. I don't have that report in front of me, but when a resident calls about any issue of infestation, they do come out on every Friday to try to, until it's actually resolved.
Okay, so she may not have been there, is that it? I just want to get to the bottom of,
That is correct. So once
Alrighty.
you have an issue in your unit, we do let you know that we are going to have someone come out. So we do have the master key, but we will let you know that we were actually in the unit to treat your unit.
Okay.
all right, thank you.
You're welcome.
How long have you been employed by concierge?
1 year.
1 year? Okay, and during that time, have you been the property manager?
Yes.
Okay. Was there any other property manager serving in that capacity other than yourself during that time?
We had a floating property manager and an assistant property manager.
Okay, and both individuals were working in that capacity during this past year?
That is correct.
Okay. When you receive complaints from tenants, or strike that, when you actually advise your tenants that you had boiler shutdowns and whatnot, how would that be communicated to the tenants?
So we have a portal that we have that actually sends emails and also text messages to residents whenever there's something that's happening within the community.
Okay,
So
and
it
that
would be
that would
emailed.
generate an email out to,
It would generate emails all to every resident that's being affected, correct?
okay. Have you had an opportunity to review the packet submitted on, and the complaint and exhibits on behalf of Ms. Cheney?
No, I did not, I'm sorry.
All right. If I can, if somebody, do you have a copy?
a copy of the packet?
Yeah, if
Yeah,
you
I can go
could.
grab it real quick.
And while he's getting that, you mentioned airflow in terms of having a vent on top of the building that would draw in air. How does that make its way into the individual apartments?
I cannot really say, I'm not that so savvy on the maintenance end of it, so I apologize. My maintenance director would know better than I would when it comes to that, I'm sorry.
Okay. Do you know if there's any ductwork in the individual bathrooms of the units that would provide fresh air or allow it to be vented?
Not 100% sure.
Okay. Does that packet have tabs?
No, it does not.
Okay. Maybe just.
Is there a specific page you want?
Yeah, but it's not numbered.
I can find it.
So there's a section titled, it should say File Tab 6, Correspondence Between Tenant and Landlord. Where's page of it?
Should be towards the back. There's 8 tabs and it's number 6.
Just let me know when you're ready.
I'm ready.
Okay. And there's a section within its file, it says File Tab 6, which is correspondence between tenant and landlord. I asked you earlier, if you could turn to the first page after that cover page.
Yes.
There's a page that says beginning with good afternoon, followed by we will have water shut off in buildings 100, 200, and 300 from approximately 10 a.m. to 1 p.m. on Thursday, October 27th. Thank you for your understanding. Do you see that?
Yes, I do.
Okay. Is this the type of notice that you said they would be generate email notice through the portal and otherwise to the tenants advising them of any issues such as boiler shutdowns or other issues with the property?
That is correct.
Okay. And is this, this is something that typically the landlord or you on behalf of the landlord as property manager would issue?
Property managers or the assistant or even the maintenance.
Okay. And it is accurate on that page. It lists your mailing address as 98 Cold Spring Road.
That is correct.
Okay. And I think in subsequent communications, I think if you turn to the, I think it would be the 5th page in the packet. It appears to be a sort of a different format. Dear residents of Concierge begins on that page. You
Yes.
see that? Also listing is kindly, it says kindly management. This is our mailing address is Concierge Apartments, Rock Hill, 98 Cold Spring Road, Rock Hill, Connecticut, 06067. I read that correctly?
Yes, you did.
All right. I don't have any further questions. Anyone else? Ms. Cheney, do you have any questions?
Not really a question, more of a comment. I did want to say.
Should I?
Switch over here. I need you to probably be on the mic, just so it's for the record.
And if it's a comment, if it's your own evidence, you can provide that after this witness ends. So you really, it should be a question, if you have any questions for her. If not, I'm sure the chairman's going to give you another opportunity to present whatever rebuttal information you'd like to on your own. if that
Exactly,
makes
that's
sense.
more precise. Do you have any questions of this witness so we can tell her if she could step down or not?
No.
Okay. You may step down. Thank you for your time.
Thank you.
Okay, Ms. Cheney, you can take an opportunity to be brief.
Do I have to say my name?
No.
I just wanted to say that maybe I wasn't in the apartment. If there were 9 times, perhaps I wasn't in the apartment those 9 times. That's basically all I wanted to say. And, well, the only other question or comment I wanted to say is that, to my knowledge, tenants aren't responsible to pay for sewage, and we were charged for sewage waste.
Okay, and are you making a claim for that?
I
Or is
just,
that just more of a notation?
notation, I guess.
All right. Counsel, do you have any questions with regard to this latest testimony?
I'm just going to object that we were not on notice. This was an issue ahead of time. It wasn't part of the complaint form.
It doesn't look like it's part of the case anyway, so.
Yeah, I'm not really prepared to respond to that specific issue.
Yeah, I think Ms. Cheney indicated that it's not part of her complaint, it's more of a notation. Did I state that correctly?
Yes.
Okay. Anything else? Ms. Cheney?
No.
Thank you. Okay. Counselor?
I just wanted to make sure that my paper, good, okay, yeah.
We're good, okay, all right. So turning to that point, I think we would close the evidence portion of the hearing, and at this time, we can deliberate, and what you may see is, some people may have seen this as something we normally do, and some people this might be strange, but what we do is we openly deliberate as to what our thought process is and ultimately what our ruling is going to be. So you will see that live. There's no other opportunity for presenting of any evidence or any issues. That portion of the hearing is now closed. You will see the commission now go into this portion of the hearing where we're going to deliberate and then issue our ruling. So with that said, anything else that I need? No. All right,
Oh, okay. My intention.
Commissioners?
My intention in asking the question about the variance of how many times somebody came and did something, okay, sprayed or whatever, was I heard one thing from one person and another from another person, and I felt it was my obligation to get to the bottom of what the variance was, and whether there wasn't, an an explanation for it.
Understood, understood.
Okay. You know me. Right?
No, no,
I hear one thing, I hear another thing, and I got to get to the bottom of what it, what it really was, okay? Because
okay,
that was it, okay?
understood. Do you have any?
What exactly are we,
So it appears that from the complaint and from testimony is essentially, and correct me if I'm wrong, if I'm understood it, but the way I've understood it is she no longer lives in the apartment.
right,
She has since moved, but there are certain expenses that she's making claims for with regard to addressing the cockroach infestation.
right,
It appears, as well as that she had seeking, compensation for having to put her cat out of the apartment, which I
Yeah.
believe, if I understood correctly, was an additional $50 per month for the cat.
Right.
But it was during a 3-month period, which the cat could not live in the apartment with her for 3 months, so that'd be about $150 that she was looking for, and as well as, I think, just the conditions as a result of not having that hot water, irrespective of the attempts to fix it, and how it affected her living.
yeah,
So I think all the while that, I do note, and I'm happy that the landlord did spend the money and the time to attempt to address the cold water, hot water issues rather, by, getting a new boiler, and I'm sure that would come at a great expense. I'm also noting that, obviously during that time, they're also, I would assume, be receiving rents from not only Ms. Cheney, but of the rest of the tenants who would have been without hot water during that time. So they've certainly received the compensation in the form of full rental payments, I would assume. But in particular, more what we're trying to decide here is with Ms. Cheney, is during the time she was out, the use of hot water during a 22-day period, though not being consecutive, because obviously it's an issue, but that she's paying full rent for heat and hot water, or at least hot water rather. So that's a concern of mine. I don't think we're talking a lot about, a substantial amount of money here or issues, but I do recognize the attempts by concierge to address it, but
yeah.
it is what it is, So. So essentially, I think if that addresses it, I think it's compensation with regard to the being without hot water for a certain period of time
Right.
while paying full rent,
the cat.
the cockroach infestation as
Yep.
well as the cat. So, I don't know, at this point, if anybody doesn't have any other questions or statements, I would say if you want to, I'd entertain a motion on how we would decide. And ultimately, we're going to decide is if it warrants compensation, have a finding for the complainant, or is it a finding for concierge? Now, if it's a finding in favor of concierge, it ends there. It's a finding in terms of that we feel that the tenant should be compensated for one thing or another or all. We have to make that finding. And then the next finding would be is if that is appropriate, what amount would then be appropriate to compensate the tenant? So it seems like we have a couple of different options
Yeah.
depending on which way we go. And then, like I said, if it's in favor of concierge in terms of complaint, because the tenant does have her claim and certain burden and what evidence she provided, if it's in favor of concierge, the inquiry ends there.
Well,
And if I could, one thing I would just throw in, I think the word compensation is fair, but it's not compensation like damage compensation. What it would be a rent, it'd be, like essentially a rent reduction, that there was a period of time in which she shouldn't have had, if you found in that direction, that she shouldn't have had to pay the full amount of rent and should have instead have played to whatever, what adjustment you think is reasonable in the event that you found in that fashion.
I believe she should get compensated for the water problem, hot water problem, and her items that she had to buy for the roaches, and also for her cat having to, and I'm thinking, is this a reason that she had to move out?
No, we can't.
Okay.
We can't ask a question, but
Okay.
yeah. But So with that, I mean, is that, you want to make a motion?
I make a
For us to
motion-
consider?
Yeah, I make a motion that she gets compensated, the tenant gets compensated for those issues.
Second?
Yeah,
Okay, second by, first by Commissioner Yo and second by Commissioner Stiglitz. Okay, all right. All those in favor? Aye. All those opposed? Hearing none. The ayes have it, unanimous 3-0 in favor of a finding for the tenant. The second issue is whether, what amount we feel is reasonable and appropriate given the circumstances here.
I think I would agree on the boarding of the cat, compensating her for that,
That's $150.
right?
Okay.
I think that concierge did try to fix the infestation problem with a number of visits, some unbeknownst to the claimant. And in my comment there would be that they do a better job of informing the tenant that they're there each week when something like this happens, even though the tenant is not there.
Right.
So I would say that I'm not in agreement with that. And I think it behooves us to look at the absence of hot water, which can be a major problem.
Yeah, especially, I mean, things do come up. It is what it is, but you're still also paying full rent for
Well,
that.
you're paying, yeah, you're paying full rent. I would say that, having lived in apartments for a number of years all over the world, unless you actually have a house where the boiler goes down, okay, believe me, it's not a pleasant situation. But I think that the landlord did do a good job of trying to correct the problem and then ameliorating the problem. So I kind of lean towards maybe looking at splitting the difference, so to speak. If they were out of the hot water for 22 days.
What was that?
What was that?
It's not an alarm. Okay,
I
we'll
know.
continue. Yeah, in terms of,
I
okay,
thought somebody was trying to get my attention as I'm talking, okay, I'm the kind that asks questions, I'm sorry.
you have 22 days. If you're talking about numerically
Yeah.
splitting the amount of time without water.
I think that she should get some compensation for that, off
Okay.
of the rent. But, I think that it has to be reasonable in terms of an expectation that occasionally equipments fail, okay? And you've got to take that into consideration.
Okay, so keeping the tally where I got it, I think that, if I heard you correctly, you believe it's appropriate to issue a reduction with regard to the cat, and that's $150. In addition to that, you said that, can understand there's been some reasonable efforts by the landlord to address it, but things happen. But at the same time, the tenant has paid full rent with the expectation that they would receive services such as hot water. And so that's an inconvenience and an effect on their living condition. You talked about splitting the difference on that in terms of monetarily, how do you put a number on that? What are your thoughts? The rent, mind you, was $17.59
$59.
a month,
1759,
22
There-
days without, yeah.
I guess I kind of look at it, that's the monthly rental, okay? She was without for 22 days.
That's almost a month.
That's almost a month,
Yeah.
but you have to expect that, sometimes there is equipment failure. And I'm for splitting that.
Okay, with what number, though?
Half of 22 days.
Okay, so it's 11 days, but how monetarily, what money would you place on that for compensation.
Whatever it comes to in terms of,
I did you can double check my math, but I just took the 1,759 divided by 31 days,
Okay.
and then that's a $56.74 a day. And if you multiplied that times 11 for the one half split, the difference, my math came up with $624.16. But like I say, I went to law school, I'm not an engineer, so hopefully the math is right.
Other question I want to pose to you is, so I'm doing the quick math. I got 150 and 624. And of course, this is your motion, so you determine if it's going to, it's up to you. I'm just keeping a tally. Anything with respect to the cockroach infestation, the money's expended to pay for that herself. She testified and I believe submitted documentation that was up about $200 of her own money.
I think that I would say that the landlord did an honest job of trying to kill the, the infestation. Having lived in apartments all over the world for most of my adult life, until moving here to Rocky Hill and buying my own house. That's an expectation that you have when you're living in large complexes where, there are a lot of people with a lot of problems, okay? So I kind of would lean towards he
More so.
more so, and maybe she was unaware of the fact that he was, that the landlord was there every week trying to fix her problem. As I said, they should do a better job of informing the tenants that they're there every week, and maybe, that would stop people from going out and getting their own stuff, okay?
Okay.
So
So
that's the thought
And
process that I
again,
used.
there can be a process, I mean, would be your motion ultimately, but my tally is that it's 150 for issue with the cat boarding and the excess rent that she was paying for that when it wasn't otherwise able to use it, and 624 for the splitting the difference on the heat issue, total of $774. So are there any other items? And of course, if, Commissioner Yo, if you have an amendment to any motion that Commissioner Stiglitz puts up, we'll certainly entertain that. But right now, Marty, if you want to make a motion,
I make a motion that we
774?
774.
Okay, so just to be clear on the record, because we're probably talking over each other a lot, the motion is to find an award in the amount of $774 to the tenant. Is that correct?
Yes.
Okay. Do I hear a second?
I second that.
Okay. Any other discussion on it? Okay. Hearing none. All those in favor?
Aye.
Aye. The ayes have it. This is an award of $774. I want to make a note of that is, I think we should probably done the motion, so I want to make this just to address the payment terms, because I know this tenant does not live there currently. So I may need to ask help from our town staff with regard to this, but just so we build this into, and so it's clear, in some situations where there's been an award, we have a rental reduction for rent going forward. We don't have that situation because the tenant's moved out.
Right.
But however, in this situation, we have to address how we're going to get compensation. I would, Ms. Hicks, if I could ask,
Sure.
is it still correct that the finance director of the town of Rock Hill receives payments can receive payments with regard to any awards by this commission?
That is correct,
Okay,
yes.
and then they can turn around and issue a check directly to the individual?
That is correct.
Okay, so in this case, I'd like to make a motion with regard to Ms. Cheney's award, is that within 30 days from today, that concierge be directed to issue a check payable to the town of Rock Hill and sent to the finance director for the town of Rock Hill within 30 days of this hearing in the amount of $774. And at that point in time, that the town will then send the check promptly to Ms. Cheney at her new address for $774. Do I hear a second?
I second the motion.
Okay. All in favor?
Aye.
Aye. Ayes have it, pass. Thank you. We're going to turn to the next complaint if we're ready, and I understand that individual is appearing by Zoom pursuant to the notice. So we're going to have to, do you want to take a brief recess, or do you need to?
I'm in
or-
a recess.
We'll take a brief recess for now. Go off the record.
Make sure he's pulling the screen.
Okay.
Quick question. We got a little technical difficulty with one of the monitors up here.
Once an action has stopped.
Okay,
All right.
they got it working?
Yep.
Okay, good.
All right, we're going to go back on the record. Okay, I'm going to reconvene the Fair Rent Housing Commission meeting, beginning with case number 2023-02. Pardon my mispronunciation, but Deharaj Sony? We don't have audio? Mr. Sony's is attending by Zoom, so just be a second. I don't think we have audio.
Would we be able to get the case down, or
Yes, if we also,
He hasn't done it.
okay,
He's trying to get the screen down.
we'll try to do that. The only other thing I think we'll need is audio. Can any of you guys hear him?
No.
Is there a master on the Zoom in terms of controlling audio?
He's working on it right now. You can
Okay.
see him on the screen.
All right, thanks.
Hi, can you guys hear me now?
Yes.
Yes.
Hello. Yeah, I just joined from my phone. I think there is some issue with my laptop.
Okay, we can hear you now, though.
Can you hear us?
Okay, can you guys see me as well?
We can see you and hear you. Can you hear us?
Okay, perfect. Thank you. I can hear you guys.
Okay.
Okay, you can call me Sony. Last name Soni.
Okay. Sony? Okay. We just lost the screen.
We don't need the screen.
We don't need the screen anymore. Why?
We're
'Cause
we're looking
Well,
at
he
it.
can't, but they,
They need.
counselor needs it. Concierge
okay.
needs it. Okay.
Okay, so about my case, I just want.
Okay. Yeah, just
an
a
update.
second. Just a second. So, Mr. Sony, my name's Jeff Thoman. I'm the commissioner. I'm one of the commissioners on the Fair Rent Housing Commission. I don't know if you've had an opportunity to hear the earlier or the beginning of this commission's deliberations. I'm sorry, hearing with regard to Ms. Cheney's case. But I wanted to again reiterate there's a procedure that we're going to go forward with. I want you to understand that the commissioners have read your complaint and file. We've also had the opportunity to review the materials that were timely submitted on behalf of concierge. So the commissioners may have some questions of you, and if they do, prior to those questions, you're going to be sworn in as a witness, which we'll do that in a second. And they may have questions of you because they've read the packet, and they may not have questions of you because they read the packet. Depends. After you present your case, and after we believe we've heard from you, and we don't want you to repeat anything that might have already been set forth in your packet, but after you've had the opportunity to present your case, the concierge and its attorneys will have the opportunity to ask questions of you through the commission. They're going to ask us the questions. We will then repeat them to you to the extent that we believe that they're relevant and focused on the issues of this case. You will also have that opportunity to do so with concierge after they present their case and defenses, in which time, after they've been questioned by the council, by the commissioners, if any, we will allow you the opportunity to ask questions of concierge witnesses or attorneys through us. And then we can in turn ask the questions of concierge accordingly if we deem your questions to be relevant to the issues in this case. Do you understand?
Yes, I do.
Okay. With that said, I'm going to have you sworn in by the town's attorney.
Can you raise your right hand?
Yes.
And can you state your name and address?
Yeah, my name is Dheeraj Soni, and my current address, I am staying in Ohio. My previous address, I used to stay in 400 Cold Spring Road, Rocky Hill, Connecticut, apartment D410.
And do you swear or affirm, whichever the case may be, that all your testimony tonight will be the truth, the whole truth, and nothing but the truth?
Yes, everything is true. I swear to God. Yes.
Okay.
Thank you.
So, Mr. Sony, if I understand from reviewing your claim in this matter, that you had previously resided at 400 Cold Spring Road, apartment 410, correct?
Yes.
Okay, and at a certain point in time, you moved out. Was it this past September?
Yes, I moved out 2020. This year, September, I moved out. Yes.
Okay, and your issue is that you were filing you had a complaint because of the rental increase that your rent increased $226 from $1,591 a month, correct?
That is one of the small issue. I have like multiple issues.
Okay, what are the claim and the relief that you're seeking here today?
Okay, so first thing is when I moved in concierge, it was in 2021. So at that time, when they gave us the apartment, I stayed here for 1 year, and later at the time of extension, I think the manager was Charlene. I have her emails with me. So I requested Charlene that I have few things to be fixed in my unit. If you do that, then only I'm going to extend my lease, or else I'm going to leave concierge. It happened in 2022. So she promised me that she's gonna fulfill all the issues related to D410. Then by her commitment, I signed the lease, I continued, but from 2022 to 2023, they never fixed the issue. I have like 8 to 10 emails on that. And I got response from Charlene as well. And I just got the response, but they never worked on it. And later, when in 2023, July, when my lease about to end, before 2 months, I went. At that time, the manager was Melissa, I guess. So at that time, I asked her that I want to extend my lease. I sent her email saying that, could you please send me a renewal offer letter? But nobody responded me. I went to the leasing office like multiple times. Nobody responded me. And I have emails sent over to Melissa. She didn't respond me properly. Whenever I go to the office, the entire, every 1-2 months, the management used to, I used to see the new faces of the management. Nobody responded me properly. My lease got ended in 2023 July. I had been requesting them 2 months ago that please extend my lease, but nobody responded. And finally, I got frustrated and I went to the leasing office I think in August, and I told them that I'm leaving on September 2nd. So they said that they are not going to charge me anything. But I had very bad experience with the concierge. I sent an email saying that, could you please confirm me in the email that you are not going to charge? They sent an email acknowledging that they are not going to charge me anything for that. Once I vacated, I came out of concierge, I came to Ohio. Then I have seen that they have charged me for the lease breakage around $2,800. So that is one of the big issue I have. And the second thing is in 2022, I used the house for 2 months without using the master bathroom. The entire wall was broken, and even I have the emails for that. I didn't use my master bathroom as well. The management, whenever I go to the management, every time they always give us a reason that we'll send you. Around like 2-3 months, I have the emails starting from October to December. I got only one response from Charlene saying that they are sending people to fix the house, but they never send it. So those are the issues I have with me, sir.
When you said that with regard to the bathroom, you said the wall was down in the master bath?
Yeah, for the master bathroom, the wall was broken. When we put the curtain, and at the right side, there is a wall tile. So whenever we bath, my unit is D410. The water goes from the wall, it goes to D310, third floor. So they asked us not to use it, and they took the shower out. But they never fixed it. They said they're gonna fix it in 1 week. Like 3 months, I used, me and my kids, my wife, everyone, we used only guest bathroom for 2-3 months. And I have the emails requesting every week, please send someone, please send someone. And they promised us that they're gonna paint the entire unit. They never did. They said they're gonna clean the entire kitchen. They said they're gonna fix the kitchen, everything new. They never did it. They said they're gonna change the carpet. They never did it.
Okay, Ms. Sony, let me ask you a question. When did there come a point in time where they actually fixed the wall in the bathroom such that you could use the master bath?
That happened around in December 2022. They did.
Okay, so it was, how long had you not been using the master bath?
Around more than 2 months, less than 3 months.
Okay, understood. Do you have any questions? I'm asking the commissioners now, Mr. Sony, if you can't see me because I'm behind a movie screen.
I can see everyone.
Okay.
Yeah.
Okay. Do you have any questions, commissioners? No. Okay. Ms. Sony, at this time, I'm going to ask Concierge's Council if they have any questions of you, in which time, just understand that they'll ask questions indirectly of you through the commission, which we will then may repeat to you.
Okay.
So I just ask,
I'll make a
right?
note of it.
Okay, so just if there's nothing further, we're going to ask Concierge Council if you have any questions.
Just a handful. Ryan Hoyler, Robinson and Cole for Concierge. Mr. Sony, am I pronouncing that correctly?
Yes.
Okay, thank you. Just want to confirm, we have your packet here of everything that you sent in to the Fair Rent Commission. You mentioned that your understanding was that certain things would be fixed and prior to you re-signing your lease in 2022. Is there anything in your lease that you're aware of that speaks to that issue?
Okay, Mr. Sony, did you hear that question? I'm just going to interject because
I heard.
the commission, it's sort of, it may be awkward, but I understand
Should
what
I be
council.
asking you? And
Yeah,
then-
yeah, if you could, just so it might be a little bit difficult. Yeah, so you've heard the question. I know it was directed to you, but it'll be directed to the commission. If you've heard that, are you able to respond?
Yeah, I can respond to that. Yeah.
Okay, go ahead.
Okay. So what he's asking is, do I have anything on the lease? That is what he's asking, right?
Yes.
Yes.
Okay, so I don't have mentioned in the lease that they're gonna fix all the issues, but I have the email from Charlene, the concierge manager at that time. I have the proof of her email acknowledging that we're gonna fix the issue. That is how I have the confirmation from her via email. I think I have provided you guys the email or not, but I have with me right now in my mobile.
I'll ask. Yeah. Understood. Has Mr. Sony, is the right way to do?
Yeah.
Have you paid, or has he paid the lease breakage fee? Or, yeah.
Mr. Sony, have you paid the lease breakage fee?
No, I didn't pay the lease breakage fee because there is no lease at all, because the lease expired on July and I vacated on September. So there is no lease. So to break. And I requested multiple times for the renewal of the offer letter. They never sent me. I requested for like 2 months. They never sent me. But I got the confirmation via email saying that we will send you, we are working on it, but they never sent me the lease. So I didn't get a chance to sign the lease, but still I understand that why they have charged me for the lease breakage when there is no lease.
Just one or two more quick ones. You mentioned that you had reached out in July to attempt to release the unit. There are no communications in your packet that speak to that. I just wanted to see what your understanding of, did you email about that, or was that a phone call? How did that happen?
Do you understand the question, Mr. Soni?
Yes, I understand the question.
Okay,
Yes.
and if you can answer.
I have the emails, and I have came to the office. I have called them multiple times. I came to the office multiple times. I have sent my friends multiple times, and I have the emails also. I can look for it. I can send again if wherever you want me to send. I can send it that. But I have the emails and got the confirmation saying that we are working on your leasing thing. I think I have sent it, but I have the email confirmation as well. I think that is an default message email from the concierge I received.
And then one last question. The case summary that was provided to us mentions that you have complaints about cockroaches in the unit. I didn't hear anything about that in your testimony, and I don't see anything in the packet that relates to that. So I just wanted to understand what your, position on that was. Is that a complaint that you have?
You can go ahead and answer.
Yeah, actually not only my unit in the 4th floor, the entire apartments in that row, because of the trash room, I don't know what exactly we call that. Because of that, all the units had issues with the cockroaches. So I have bought like multiple cockroach killing spray bottles. I sprayed myself like many times. I complained many times. They always used to come. They used to keep something at the corners, and they used to go. That's it. They never fixed the issue actually. Even that was also one of the issue I faced. They always say that we're gonna fix it, but they never do it. They just come. They keep some glues at the corners, and they just go.
Thank you, Mr. Soni. I don't have any further
Counselor,
questions.
if I could ask you just wait. Mr. Soni, this is again Chairman Thoman. I do want to just point out now, I'm going to turn to my left over here and request assistance from the town attorney as well. We're the Fair Rent Commission. I understand the nature of many, if not most of your claims seem to be something that should be raised in landlord-tenant court with regard to rent breakage breakage fees, fines, excess rent paid in terms of what was promised. It seems to be more akin to a landlord-tenant action for damages based on amounts you paid rather than what I would think the proper purview would be for the Fair Rent Commission in terms of the rent. I'm not saying that you don't have a claim one way or the other, but it seems to be that something that would be before another forum, more properly before a landlord-tenant court. That's why I was trying to understand the nature of your claims. I gave you some latitude in doing that, and I wanted to see if counsel for concierge would address it. And it seems, again, those would be something that sounds like that would have to be decided in the Superior Court rather than the Fair Rent Commission. Am I correct in that assessment?
I think
Mr.
you
Slater?
are with several points. There was the testimony, if it was during the period of the rental, and I think it was, about the loss of the ability to use the master bedroom because of the leaking that was going down the wall. And that could be something like in other hearings, you could consider whether there'd be a rent reduction, but some of the other elements in terms of, fees and penalties and all of that, I agree with you. That is something that would be the subject of the housing court in the event there
Okay.
was.
And that's exactly where I'd say that when I said most of it, it seemed like the bulk of the claim related to something that would be in housing court. Whereas I think the scope of our claim would more be on the conditions, including the bathroom issue or loss of the master bathroom. But do you understand, Mr. Soni, that with regard to the penalties or charges, that may be something that's more appropriate for claim in Superior Court or before the Housing Court, but not before this commission. Do you understand that?
Yeah, I understand. So I have small clarification. So do I have to again go back to the Superior Court or anything? You can guide me on that, because this is the first time.
I can't give you
I'm
legal
in facing
advice, but
problems.
what I can tell you that I cannot determine those claims. This commission cannot determine those claims with regard to the charges that you said were the relating to the overcharges for rent, or whether you broke the lease properly, whether you complied with the notice requirements in that regard. That's not properly before this commission. I did suggest that you may have that in another forum, perhaps the Housing Court, but beyond that, I can't help you. But we can consider, which I understand to be the balance of his claim, I believe, is the loss of use of the shower based on his testimony. I think that's probably narrowing the scope. That's it.
Okay, sure.
Okay. Do you have any other questions,
No,
Counselor?
no further questions at
Okay.
this point for this witness.
All right. Mr. Stoney, I would say you're still under oath, but I'm going to ask you to hold off, because we may have, concierge may have some of its own testimony and presentation with regard to their side of the claim. After they're done, you're going to have an opportunity. You can ask this body, this commission, to pose questions to concierge and its attorneys or any witnesses they put up with regard to any of their presentation of the case, but it would be narrowed. The issues are going to focus on what's remaining in this claim. Understood?
Okay.
Okay. Just be a second. So I'm going to, at this time, Counselor for concierge.
Yes, thank you. Again, Ryan Hoyler, Robinson and Cole for concierge. Before I call my witness, I'd just like to point out a couple of the documents that were submitted last week, I believe on December 4th. I understand the commission has previously said that they would consider those documents. So one set of those documents is the set of work orders. If you compare the set of work orders and the correspondence that is here in the file provided to as part of today's case, you'll note that there is no work order or correspondence relating to the allegedly broken shower. The understanding that we have from the complaint that was filed is that there were tiles that were coming off of the wall, and that's it. And obviously my witness can speak to that briefly as well. And I understand that the commission has kind of decided that this is outside their purview, but nonetheless, the final page of the ledger that was also submitted for Mr. Stoney will show that while he was initially charged the lease breakage fee, it was removed from his account within days. And then finally, the last set of pictures is the condition of the apartment at the time that it was vacated. Now, I do understand that at least one of the pictures in there, probably two, shows the broken countertop, which I understand is part of Mr. Stoney's claims, and I will have my witness speak to that in a moment. But I did want to point out those documents.
Just have one question. I know the witness is probably going to address it, but maybe I'll just tee up the issue. One of the things you said, there was nothing in that document you submitted on December 4th that relate to the shower issue.
That's correct.
Will you or your witness be able to address, it appears that Mr. Stoney had some complaints, at least documented under tab 6, correspondence between tenant and landlord. That looks to be in October 19th, 2022. I believe maybe an email or something through the portal from Mr. Stoney to a Charlene saying about issues, an update on the request regarding the master bath water leak that leaks into apartment 310. And then there's a response by a Charlene Thomas, who I'm assuming is concierge,
Bless you.
that said she's going to get a team lined up. Do you have anything that speaks to that issue?
I believe my witness will be able to speak to it generally.
Okay.
Yeah, there's I think there's the one email that says that there were tiles that needed to be fixed. And Yeah, we can speak to that generally with my witnesses. However, I would point out that the current maintenance person we have, and I believe he testified at a prior hearing here, has only been in his position since about October or November of 2022. So things prior to him, it becomes a little bit more difficult for us to have someone testify to. But as far as firsthand knowledge, the property manager will be able to testify to some of this.
Okay, thank you.
At
If
this
you want to
point,
call your witness?
Yes, at this point, I would like to call Melissa Davis.
I'll just remember, still under oath.
And just for the record, I'm leaving a copy of the packet here in case you have any questions.
Okay, and I think she may be, you're still under oath. I just want to remind you that way so we can avoid the swearing in the second time.
That's what I would.
I should know better. All right. Counsel, you may begin.
Ms. Davis, just again, real briefly, what is your position at Concierge? If you want me to skip this, I'm also happy to do it too, but it's a new hearing, so I figured we might as well.
It's part of the record. You don't
Yeah,
have to do that.
okay. So I'm just going to get right into some of the questions then. With regards to apartment D10, in the packet that we submitted of, and you may not have it in front of you here, but it's your work order logs. There were work orders that came in early 2023 with respect to the issues that are listed, that the witness, the claimant has brought up in his testimony, including the broken countertop, broken drawers, the microwave, and tiles in the bathroom. What is your understanding of what happened around the time that those complaints came in? That they came in 2023 at least?
My understanding is that the tenant basically gave notice to vacate the unit, and that's why we didn't address the issue, because he was going to be leaving the unit.
So, to your knowledge, did the tenant attempt to release the unit in July of 2023?
Correct.
The tenant did attempt to release the unit?
Correct.
And did the tenant choose not to release the unit?
Not in July.
Not in July. When did the tenant inform you that they would be vacating?
I want to say he was currently on a month-to-month, and sorry, and I want to say I think he left the unit. I want to say around September.
Okay. Did you approach the tenant at the time that the complaints in the work order log that I submitted came in February or March of 2023?
That would be the maintenance supervisor.
The maintenance supervisor did. And do you know what the discussion generally was at that time?
Also was given to him that he would be vacating the unit.
Okay. So to clarify then, the reason that Concierge did not fix some of these issues like the broken countertop and the drawers offline and things like that is because it was Concierge's understanding that the tenant would be vacating the unit.
That is correct.
And then the idea would be that Concierge would fix those things once the unit's vacated.
That is correct.
Okay. Are you aware of any complaints regarding the bathroom in D410?
No, I'm
Okay.
not aware.
And we submitted pictures just of the unit as it was left when it was vacated. I'd just like to show the witness those pictures real quick just so she can confirm that it is apartment D10, if that's okay.
And this is from your December 4th packet?
This is from the December 4th packet, correct?
Okay. Thank you.
These were from D10.
D410.
D410?
Yes. Yes.
Okay. So I'll just. So just to clarify then, those pictures that you looked at, those are from D410 when the unit was vacated, correct?
That is correct.
Okay. I don't have any further questions right now.
Counselors, commissioners, do you have any questions?
I don't right now.
Mr. Stoney, do you have any questions of this witness and her testimony?
Okay, I have a question. So they are saying that they have the pictures of the condition of the house is very bad when I vacated the house. The condition was bad from 2022 when I extended the lease. From 22 to 23 when I signed the lease, when Charlene told me that she is going to fix all the issues. From then till I vacated from 2023, that whole year they never fixed the issues. So the condition became worse. because nobody showed up from the concierge and fixed the issues. Because of the countertop was broken and the hole, and it was all the stinks. The kitchen always used to stink. The cockroaches used to come from there. Because of that, they never fixed the issue. And by the time we left the house, it became worse. Even the carpet, even the paint, everything.
Okay, Mr. Sony, my issue is, so I'll take that as rebuttal because it's not a question of this witness, but we'll still consider it. But my question for you is, do you have any questions of this witness, or may I allow her to step down?
Okay, I have one question. From May, I've been there. I have, I personally spoke to Melissa that I want to the lease renewal. She said she's working on it, but she never worked on it. I don't know, when I came to month, I never got informed that I am on month to month. And even if the rent I paid, that was not month to month. Because month to month supposed to be extra, but I paid the same rent till September.
Okay.
I never got informed that I was on month to month. Yeah.
Understood, Ms. Sony. What's the question of this witness? Do you have any questions? And no is a perfectly fine answer.
No, I'm good.
Okay.
Sorry.
You may step down. Thank you. Ms. Sony, we understood your testimony to be rebuttal testimony to address some of the issues that are raised. You have that opportunity to make those statements, which we'll take in due course. Counselor, do you have any questions of Mr. Sony based on what his latest rebuttal?
I do not.
Okay. That, Mr. Sony, the concierge, counselor, thank you so much for your time. At this point, we're going to close the evidence portion of the hearing. And in case you didn't hear before, we're going to be deliberating. The three commissioners that are here today are going to be deliberating on the issues that you've advanced. You'll hear us talk out loud. It's not an opportunity to offer any more testimony, more evidence, because that portion of the hearing is closed. So at this time, I'm going to turn to the commissioners and the thoughts on deliberation with regard to Mr. Sony's claim. And any thoughts?
Is it, the rent increase, is that still on the table?
No, I think the scope of the claim appears to have been narrowed down to the condition of the apartment, some complaints with regard to various things that haven't been fixed or in state of disrepair, as well as the alleged condition with regard to the master bath shower. That's it. And whether we feel that that is something that the rent was otherwise, under those circumstances, unreasonable or harsh and unconscionable. Now, of course, bearing in mind, Mr. Sony is no longer living there, so the same thing would apply as the prior complaint, is that if there is some sort of award that we feel that's reasonable. I'm sorry, we may want to do this at this point. Oh, no, he's still on the screen, so we have to keep the screen down. Yeah, absolutely. And then whether we think that's, again, an award that we feel is necessary, and of course, that would be the first issue to decide if there's an award that's warranted. If it's not, that the inquiry ends there, and we have a favor in finding in favor of concierge. If it's something that we feel an award should be issued and we take a vote on that, then we have to put a number on that and what we feel is appropriate.
Yeah.
So I guess if there's any other, again, I think the bulk of his claim, I think we've already I don't want to rehash it too much, is that has to do with charges and whatnot in terms that would probably be more appropriate for housing court, which is not going to be something we're deciding here. So again, it's the condition of the apartment based on the evidence presented, as well as this bathroom condition. So what I viewed is, I understand that the issue is raised. I saw it at least in one piece of correspondence in Mr. Sony's packet about the bathroom. I don't see much more evidence of being offered that. I understand from his testimony it lasted about 2.5 months, that issue, but I don't see any issues other than to see that the concierge indicated that they were going to come back and fix it. I don't know what the condition of the shower was beyond that. And also, I do see the evidence of certain conditions that are in disrepair with regard to countertops and tables, but I do also understand the position taken by concierge that they were going to address it, and it would be more appropriate, since those claims were raised, to address it since at the time that he's vacating the apartment.
But
You know.
that was going on for quite a while. Those issues as he lived there with his family,
Now, were you talking about the,
like the broken counters and all
Counters.
that, yeah. You know,
I don't know when I'm looking at the timing of the complaints, trying to assess that, and throughout the duration of the release, I do see stuff with regard to the bathroom. It's in October, as well as March 2022. I mean, if that really was the case, that's between March all the way up through the end of the apartment, and that could be a bit of a concern. That I see a date in the packet, March 10th, 2022, where patio screen door handle broken or something's off track or torn. I don't know if those issues continued, but I do see them raised at least that early. Any other thoughts?
Sorry. Can I say something?
You cannot. Sorry. We can't take any further testimony or evidence in this portion of the hearing.
well, maybe he should get compensated, the tenant should be compensated for issues of the apartment for many months.
Yeah. I don't know, on this one.
I know, it's,
Maybe if somebody, Marty, you have, Commissioner Stiglitz, do you have any thoughts, or if anybody wants to make a motion?
Some of the issues were there for quite some time, I guess from March until September when he moved.
I believe that's at least the implication. And again, he said it was there throughout. The only time I see aside from the testimony, documentation about medicine cabinets in the bathroom off track, kitchen drawers off track, kitchen cabinet base needs support, and the like, that came in around March 10th, 2022. I do see following that, a number of work orders been created, work orders been completed, but it's difficult to determine what those specifically relate to, and that's in Mr. Boney's packet, Sony's packet, rather. Just,
so the main thing is the condition of the apartment.
yeah, and whether he's satisfied his burden of proof for that too. I understand there's allegations, it's difficult for me to make that determination.
For me too.
So, along those lines, I mean, if you want to make a motion, we can, 'cause we do have two other cases.
Yeah. Well, you want to make a motion enough?
I guess I will make this comment, as I've said in the past, as we've reviewed other claims. The landlord does provide a way in which to register your complaints.
Marty, if you
Lean
could,
into the mic,
yeah,
Oh, I'm
speak
sorry.
into the mic.
or pull it back to you.
No, it's okay. As I've said in the past, you know, the landlord does provide a method by which somebody can register a complaint. And I really would go by that in terms of what was in the system, okay? It's very difficult to go back in terms of my looking at a situation. Gee, I called so-and-so, okay, or I called the head office. That's not the way you're supposed to register your complaints. You're supposed to put them, in the pivotal or whatever they
Portal.
call it. The portal.
Yeah.
It looked to me that whatever was in the portal was handled, whether it was handled timely or it wasn't. Once you get into a situation where everything needs to be fixed, okay, I don't know if it's not in the portal, who it was reported to, how it was reported, and whether they actually, did anything. So
And again,
that's why I'm.
I agree, and I don't necessarily have any issues with Mr. Boney's complaints or frustration. However, we have the evidence before us and whatever testimony we have, and we're not going to try to speculate.
Right.
I just don't feel that he's necessarily carried his burden in that respect.
Okay. I would look at it from the point of view that I'm going to take the word, okay, how many months did he not have the use of his main bathroom?
He stated that it was approximately 2.5 months. So more than 2, but less than 3.
I would say giving him a portion of the rent back and that's for us to decide.
Okay. And they were, during that time, him and his family were using another bathroom within the unit, but they had 2 full baths as part of the unit, from what I understand from the complaint. So,
And maybe what we can do is say that, what would be the difference between a 1-bathroom apartment as opposed to a 2-bathroom apartment, and coming up with,
and his rent was $15.91 prior to moving out. It's a 2-bedroom, 2-bath unit. It's difficult to tell exactly what that would be. I'd imagine from other testimony and records of before this and what I generally know about concierge, it's been the difference between the units are at around $300 between those units. I believe a month. So if you're dropping it down, but I think that's more relates to bedroom rather than bathrooms.
well, I feel that we should compensate him for 2 months, okay?
Okay.
Yeah,
What number-
that gives the landlord an opportunity to come in and fix whatever the issue and the problem is,
Okay, so
but we have to come up with
a number.
a number in terms of not being able to use the master bath for X number of weeks.
Yeah, and I understand for the testimony, I don't have any, doesn't look like there's any photos or documentation of the condition. I know he states it, they said they were going to work on it, I just don't know, but it sounds like it's gonna be your motion, so the rent amount was $15.91. You can maybe base it off of that if you feel that there should be an award.
Can we say that $300 would cover that, do you think?
Would that be $300 total?
Mm-hmm.
Okay. You certainly could say that.
I agree with that for the tenant.
Okay. All right, do you want to have a,
The motion would be to
make an award
award
of,
for the tenant in the amount of $300.
okay,
I second it.
all right. Any other further discussion? Okay. All right, all in favor?
Aye.
Aye.
Opposed? I'll be a one opposed on that one. So 2-1, motion, Marty's motion's carried. So there's an award of $300 I will add to that motion, similar to what we did in the last claim, is that the concierge be directed to pay within 30 days of tonight's hearing, the amount of $300 payable to the town of Rocky Hill and delivered to the finance director. And then at that time, the finance director in town of Rocky Hill will turn around a payment to Mr. Sony at his new address, the amount of $300. Do I get a second?
I second.
Okay, all in favor?
Aye.
Aye, okay. All right, thank you both. We're going to turn to the, take a brief recess, 3-minute recess.
May I just make one request real quick?
Yes.
Would we be able to do the next two out of order? Only because I believe my witness is only going to find one of them, and if I could get her first. I understand, I don't want to make anyone wait any longer than they have to, so.
All right. Okay, so that, in that case, I don't have it in front of me. We're going to take,
You just have to approve that by two-thirds.
you would be looking for Marth.
Ms. Cruey, I believe, first, and then Mr. Strasburger.
Yeah.
Is that fine? We have all the parties here? Okay, is that fine with the two of you? Has no intention to testify? Yeah, okay. All right, when we come back from the recess, we'll start with, we'll take the vote, which I'm assuming
mine
will
here.
pass, and then we'll take, is Crowey, am I correctly? Yes. Okay, Crowey's
Thank you.
claim first, thank you.
Thank you.
Okay.
Excuse me, one question. Am I good to drop?
Yes, you're good to go. Thank you, Mr. Sony, for your time. Please be in contact with the town officials with regard to make sure that they have your updated address in Ohio.
Sure, thank you so much.
Thank you.
Okay, thank you.
Take care. We're going to go off the record.
Thank you, everyone. Thank you, everyone.
Ready to go back on the record? Okay, thank you. Okay. Call back into session the Fair Rent Housing Commission hearing. There's been a request off the record with regard to the order of taking of cases to tonight's agenda. There's been a request to take case number 2023-06 first, or rather 2023-05. If we need to take action on that to reverse that in the agenda, if we can get a motion
I got a motion to accept the reversal of,
of the order proceedings.
exactly.
Okay, second. All in favor?
Aye.
Okay, with that being said, motion passes. I would remind the folks, everybody's been here a long night, I apologize for that. You've heard me say the procedure a number of times and how things are going to be taken, so I won't repeat it so we can get right to it. With that being said, this next case, 2023-06, Martha Cruey, if you can come to the microphone right now, and the attorney will swear you in.
You raise your right hand and please state your name and address.
Martha Cruey, 122 Cambridge Street, Manchester, Connecticut, 06042.
Do you swear or affirm, whatever the case may be, that all testimony you provide tonight will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Ms. Curry, again, like I stated, that we've already reviewed your packet as well as the materials submitted in response to that by Concierge and its attorneys. My understanding is that you no longer live in this unit?
Correct.
Okay, and your claim essentially is that there was some heating issues with your apartment, specifically that you had heat in your apartment during the summer months, which caused your apartment to go up to around 78, 80 degrees, and you have electric heat, is that correct?
Correct.
Okay, and that caused you your heating, or electric bill rather, because your electric would apply to other appliances as well, to be in the upwards of about $400 a month. And there were some other issues with regard to the refrigerator and seals of windows and closet doors and whatnot. And that there was an issue with no hot water in the February 2023, which we may have heard earlier in other claims, that you'd been contacting Concierge about that. With regard to the $400 monthly electric bill in the summer months, what was your electric bill? Well, let me ask it a different way. How long had you lived in this unit?
I lived there from December 15th of 2022 to July 1st of 2023.
So you, essentially about 10 months?
Correct.
Okay. So you have any other rental history with them before?
No.
Okay. And did you end up moving out because of these rental issues?
Yes.
Okay. Do you have any, when did this, the issue with regard to the heat going to your apartment in the summer months, when did that at first manifest itself?
That actually first manifested in January. The first bill that I received that I actually saw was in March, and that was for 3 months' worth heat and electricity, and that was for approximately, I think, $1,000, which was about $400 a month.
Okay.
At that time.
Yeah, what I'm trying to find out is the issue where you couldn't control the heat. Is that essentially your claim, that the heat couldn't be controlled during the summer months?
It could not be controlled, period.
Period, okay.
Period, yeah. I was never able to control the heat while I was there.
So do you also have air conditioning in your
There
apartment?
was air conditioning there as well.
Or is it forced, HVAC through the
Yes.
ducts? Okay. And you would have heat while also trying to turn on your air conditioning? During
Correct.
the summer months? Okay. And you were not able to control the thermostat or to regulate the heat even during the winter months?
Correct.
And the amount for your electrical bill, when you stated it was in the upwards close to $400 a month, was that fairly consistent from January through July, or did it change?
It did finally adjust in about, I want to say April, maybe, to a lesser amount than $400 a month. but I did still notice that the heat was still going, so it was uncomfortable during that time.
Okay. And how much was your bill when you said it adjusted in April? How much was that?
Sorry, I don't remember.
Okay. Is it in the packet? 'Cause
I
know
don't
if I saw
think
that.
so. I think that I only was including it for the period of the time that it was maladjusted.
Okay.
It was around, okay, so I now own my own home, and last month it was $85 for a 4-bedroom, 2-bath house, my electric bill, because I was living there in this apartment by myself, and there was nobody else coming or going out of the apartment at that time except for me. And I had the thermostats adjusted to 70 degrees, and it was still pumping out heat and the thermostat was reading around 80 degrees Fahrenheit.
And you, what relief are you seeking from this commission?
I'm seeking $500.
$500 with, to compensate or with regard to the heating issues as well as any of the other conditions that we talked about with the,
No, I was
Lights,
looking for $500 for just the heating, so I was looking for a total of maybe $700.
what would be the 200, 200 would be representing an award for what?
For the water, I had an entire weekend where I didn't have any water at all, and then I had at least a week worth of not having hot water. I also lost some food during that time because the refrigerator seals and the freezer seals were not fixed properly when I did report that issue.
Okay. Any of the commissioners have any questions?
No, at this time, no for me.
This time, no.
Okay. At this time, concierge for, I asked if you could just stay there, actually.
Sorry.
Because we're going to, I'm pointing in your direction because somebody was behind you. So I take it you have some questions?
Yeah, just one or two.
Okay.
For the record, Ryan Hoyler, Robinson and Cole for concierge. Ms. Cruey, I just have one or two questions for you. Do you recall when you reported first your concerns about the heating in the apartment?
I don't remember right now, but I did have them listed in my packet.
Okay. And is it your recollection that someone from maintenance came, did someone from maintenance come and deal with any of this at the time?
Actually, you know what? I do remember because when I first got into the apartment, I was having a hard time adjusting the heat. So they actually came without having it reported within their portal. And they showed me how I was supposed to be adjusting the heat. There were 2 different thermostats, actually 4 different thermostats, one for each of the bedrooms and then one for the living room, actually 2 for the living rooms, and one on either side of the living room. So at that time, they did say that they showed me how to adjust the heat, and I did adjust the heat. And then the next time that I reported the problem, they said that they did come in and fix the heat, the issue, and they looked at it. And the next day, when I came back home that day, because they entered the apartment when I was at work, it had not been fixed.
Your current house that you've moved into since you've left, do you have electric baseboard heat in that house?
Yeah, no, it's oil heat.
Oil heat, okay,
Yeah.
okay.
But it was during the summer months, so it was not.
Okay. I believe that is all the questions I have for this witness.
I do have just a couple of follow-up questions. You may want to stay. With regard to your communications to concierge regarding the heat, when did you first start to make those complaints? Because what I'm trying to, I understand you may not have this committed to memory, but looking through your packet and your submissions, I don't, trying to see if we could pinpoint. I invite you to do the same. You can tell me or able to by looking at it, whether you can pinpoint dates when this first was complained of to concierge and what their response was.
Right. It was on
I do see quite a lot about
the hot water.
water and water breakage and some issues about pets.
So. It's not it either.
Do you have the packet with you?
I have the packet with me.
Okay.
But I also have the work orders that were sent to me by the, by the office of the FRC.
Are they in this packet?
I believe it's part of what we submitted on December 4th. I have extra copies if you need.
Yeah, no, I'm just was looking at her submissions versus theirs. Okay. Where is it?
I have a question.
Go ahead.
Yes, I have a question. In terms of the electric bill that you would get, it covered the heating and the electric as one bill,
Yes.
correct? And I'm going to ask, when you turned on the electric in the summer months for your air conditioning, okay, did you see an automatic increase in your electric bill?
No, it was pretty consistent.
Well,
What?
that would be highly unusual. okay?
I understand.
It would be highly unusual because basically, I own a house, okay? And when I turn the electric on for the air conditioning, okay, I go from about $69 a month, okay, for the rest of the year to in the neighborhood of $500 a month.
Understood, but this was, because the heat was on the entire time, there wasn't that much of a change in the cost per month for electricity because it was already running the heat. So the addition of the air conditioning, which I didn't use very much, I tended to just sleep with, and not get very much sleep at all because I was not turning on the air conditioning because I really couldn't afford it. So I did not turn on the air conditioning very often. I turned it on maybe for a few hours each night, and then I would turn it off in the morning.
Okay, I just want to get it in context. Okay.
Just to clarify, in that unit, you had baseboard heat, correct?
I believe so, yes.
Okay. And then separate and apart from that, for the air conditioning, you had HVAC through the ductwork, correct?
Yes, correct.
Okay. Both of which were powered by electricity.
Correct.
Okay.
I have no further questions, so.
Any further questions? Okay, no further, you can step down now. You'll have an opportunity after they present their case and to question their witness if you choose to do so.
Thank you.
Okay, thank you for your time.
Should I just stay here instead of
Yeah,
going over
absolutely.
there? Yeah,
Yeah.
so, again, Ryan Hoyler, Robinson and Cole for Concierge. Just pointing out that the packet that we submitted on December 4th includes the system complaints that are made by individual tenants about maintenance for this particular unit. You do see an entry in December. Seems like it was when Ms. Crewy probably first moved in, about the AC. However, there's not another complaint about heat not working until May 19th. So I want to point that out. I'd also like to point out, it was a discussion we had at the last hearing before this commission about generally Eversource's rate increases over the winter of 2022 into 2023, and just reiterate that for the commission. And again, I don't believe there were any additional documents for Ms. Crewy that came in on Friday. It should be, there was one additional document that I just do want to point out here that we sent in on Friday. It's one page, so if that's okay, I have a couple copies over there. I have one copy with me. I'd like to submit it now. It's a summary.
One
Stay
page.
here and explain what it is.
One page falls under the rule.
Thank you. It's a summary of one of the entries on Ms. Crewy's maintenance log, specifically related to her not having electricity in the apartment. And it shows that it was responded to almost immediately. So it's just another example of, I'll circulate more copies. I'll be happy to give this one to Ms. Crewy. But this is just one example of, and I think that's really all that we wanted to add from Friday. And then at that point, I would like to call Ms. Melissa Davis.
You may.
They'll have it.
Ms. Davis, just remind you, you're under oath still. Thank you. Bless you. Thank you.
Hi, Ms. Davis. Again, I'll try to make this brief. I understand that as the property manager, you understand generally what's happening with maintenance at the property, even though you're not the maintenance person specifically.
That's correct.
Yeah. So can you explain what your understanding of the heating and issues in Ms. Crewy's apartment were?
Yes, so there's baseboard heat, and then you have the central air that's through the ducts. And if you're, from what I heard and from what I witnessed speaking to the maintenance, the baseboard heat was never turned off when she tried to turn on her AC unit. There's different thermostats throughout the unit, as she explained. So her baseboard, the heat thermostat was not on the off position, so she was blowing AC and heat at the same time.
And you know, your understanding of requests to deal with this, were they dealt with in a timely manner?
Yes, it were.
Okay. And electricity and heat are billed separately for concierge, so you, as the property manager, don't necessarily know what individuals' electricity bills are, correct?
That is correct. That's billed. They get their own services by Eversource. We don't deal with that.
Okay. I think that's all I have for this witness. If the commissioner, Ms. Crewy, would like to.
Do you have any questions? Okay. Might want to have, if you could switch spots
Yep.
with counselors, that way we can get you on the record on your mic. And if, understand, as awkward as it may seem, I keep repeating this, but if you can direct your questions to the commission, and then we'll in turn address the witness.
So my question is that if the heat was was registering at such a point that it would be creating enough to counteract the thermostat, the air conditioning, why was that never reported back to me when I had made the complaint? So I never heard anything back about the facility from facilities or from the management office that this was what was happening.
Yeah.
Nobody ever told me how to work the thermostats. And they were often, even when I had them turned down to, say, 60 degrees, they were still producing enough heat to be at 80 degrees.
Ms. Davis,
Okay.
you able to
I am-
respond?
Yes, I am under the impression that our maintenance director himself actually went into her unit and showed her the different thermostats and how to use them.
Ms. Crewy?
That was in December, and that was strictly regarding the heat, not regarding the air conditioning. So at the time that in, say, March, or April or May, when I was having the heat still coming out of the
Baseboard.
baseboards, at that time, it hadn't been explained correctly to me, or clearly to me, about how the two systems were supposed to work, because there were so many thermostats, and they actually did tell me at the time that in December that they didn't always register evenly. So the one that was the original traditional thermostat was opposite the new thermostats, and they told me that I had to play with them to figure out how to get it to even out.
Ms. Davis, when you said it was your understanding from talking to maintenance or facilities that instructions were given, do you know when that took place?
I'm not 100%
Okay,
sure.
that's fine. All right. Do you have any other questions of this witness?
I don't think so. Thank you.
Okay, you may step down and stay, if you want, you can stay right there. You can step down, Ms. Davis. Thank you very much for your time. Do you have any other witnesses to offer?
No other witnesses, I just wanted to make another statement.
Okay.
Before I close.
Yeah, sure. I'm going to give you an opportunity if you have anything else in terms of rebuttal, not necessarily a question because the witness has now stepped down. But
Correct.
after opposing counsel has made his statement or an offer, I'm going to turn to you next.
Just again, like to reiterate the conversation that we had previously about Eversource's rate increases and understanding that. I do understand that she had mentioned the boiler earlier and having hot water. We've put that on the record already with the boiler invoice and everything else. I don't know that we need to reiterate that here. Otherwise, I think the only thing that I really have to add is it still seems to not make a lot of sense how the electricity bill didn't change as the AC was added. I'm still a little confused about that, but otherwise, again, we close. So,
All right.
So do I need to answer that question?
It's not a question, it was more of a statement.
Okay.
This is a portion of that you're not necessarily, you're not cross-examining anybody. I'm just going to give you a brief opportunity to, what they call a rebuttal. Anything that you wanted to address, make any statements with regard to the evidence that's been put forward by concierge, or something you just want to add?
So again, the reason why the bill did not change much during the summer months was because I was not running the air conditioning frequently. I was running it maybe a few hours a day and only at night. And that was why it really didn't impact the amount of the electric bill. The other thing that I wanted to state was that the first thing that I did when I got this bill was to call Eversource and to say exactly, and to ask them exactly what was happening. And I was not able to procure their statement as witness, but they said that they tallied the amount that it should have been with those rate increases, and those rate increases should not have brought it up to $400 a month for one person.
Okay. What's the square footage of your unit, if you know?
I don't remember. My apologies.
No worries.
on the packet.
Yeah, it was.
$1097. Okay. All right. Any questions, counselors and commissioners?
No.
Okay. Thank you, Ms. Cole.
Thank you.
Appreciate it. Okay, at this point in the hearing, we're going to close evidence and begin our deliberation process.
Okay.
All right. So as far as what I've been able to discern, monetarily, it appears that Ms. Curry had indicated that she's looking for an award in the amount of $500 for the heat issues and $200 for the water issues. You have any thoughts on, let's probably take the bulk of that and just address the heat? Maybe I can jump in on that. I do feel for the issues that went on here. I don't know, however, in terms of, the rate increases, I mean, we have rate increases, obviously, that we've heard here. We all have kind of sort of taken notice of with regard to electricity and energy, whether it be gas or electric, but particularly electric has gone up. And I feel for tenants that have to pay for that rent homeowners have to pay that as part of their bills as well. But what strikes me is this, I don't know, and what's been presented is an issue of functionality in terms of something was in disrepair, wasn't responded to. It might be more of an issue of, I don't know. There's competing thermostats. It sounds like, from what I can able to understand from both sides, is that both systems were competing with one another and fighting themselves. You got one was trying to, thermostat was governing how cold it was going to be in the apartment, one was going to, how hot it was, and at certain points, although it's not completely clear, but at certain points, particularly in the summer months, they were competing with one another. I don't know that the central air would have been active in the winter months, so I don't know what the issue would have been there, if at all. It just may have been an issue, as best I can tell. It's just that, again, it's not to say one thing or another, but I tend to focus on what's been presented to us, and we try to do our best to determine what the conditions were like then and what was the cause of those conditions. And based on what I've seen, it's not completely clear to me that it was a result of something that was in disrepair or something that was being ignored by the landlord. I think it was just an issue of, obviously, number one, increases in rates, electrical rates, but number two, to the extent that there was competing hot air and cold air going on at the same time, they're fighting themselves. It was just about how to adequately manage the thermostats and do it properly. So I don't know if that's necessarily a fault of anybody. It's just unfortunate.
Anyone who has electric heat and electric air conditioning has dual thermostats. One thermostat, controls what's happening. I can honestly say that personal experience from one year to the next year, this current year, my electric rate, when I turned on my air conditioning about half of the day, actually it quadrupled my
Electrical bill?
my electric bill. So, that's
Yeah,
all I
that's
can-
great.
That's all I can add to the
Yeah.
scenario.
It seems that she wasn't properly,
Maybe she wasn't instructed
Instructed,
correctly, or maybe hadn't lived in,
Yeah.
This type of unit with this type of
Yeah, with
heat and
heat and-
air conditioning.
Yeah.
But I mean,
Setup.
but basically,
Yeah.
having lived myself in various apartments, there's always, it's
A
not
learning
always
curve.
one, it's not always one.
Yeah, and there's
okay.
always a little bit of a learning curve, but unfortunately, it hit this person in the pocket, but I don't know that it's necessarily through a fault of concierge.
Yeah, this is,
It's tough. It's unfortunate, but
yeah.
yeah.
with that, we have to make a finding whether an award's appropriate in favor of the
Well-
tenant or if it's not appropriate.
If what, refresh my memory.
Oh, there's also the issue of the water, too.
Okay, the water was what, $200?
That's the,
Yeah, $200,
And what was the air conditioning?
500.
500.
yeah.
I would say.
Heat, actually.
The heat,
yeah.
okay. I would think it would be fair to say, give her the 200, okay? Because she was without, and then taking the heat / air conditioning thing and affixing, it was a 50-50, meaning maybe she wasn't instructed correctly, but eventually,
Yeah,
you should have played with it or whatever.
I would tend to agree with you on on the water. I'm willing to grant on the water issues because we've had testimony and that's been an issue. It's unfortunate those things happen, but tenants do pay rent for having that ability to have the hot water, the use of the water. It's part of the rent. So things happen, but also they paid their full rent for that time. However, I just have to just part with you, at least with on the heat issue. I don't see that as a component of this claim, of which I'm willing to give an award. But you two may disagree, and maybe we could put it to a vote. But if after this discussion you think so, I would probably request that you separate those in terms of two different votes, if you feel it necessary. But right now, I'm leaning towards
No,
more
we're
of a
just-
water than heat.
I'm just trying to
Work through it.
work through, what we should do in all fairness. All I can say is, my own personal experience, I have dual thermostats in practically every room in my, in my 4-bedroom, 6-bath house, okay? And you quickly learn, no.
Yeah.
It's not 6, it's only 3.5 baths,
Gotcha, yeah.
okay? You quickly learn how to
Manipulate and operate them.
manipulate until you get a comfort level, okay? So I'm willing to be very flexible about that, okay? It's a learning curve, and,
But is it a learning curve that warrants an award for it?
no,
Okay.
no.
I think we're in agreement on that.
Yes.
So if we're focusing now, we've kind of clarified the issues down to the water issue.
Right,
You, Marty, indicated that you were willing to make an award for $200 as reasonable compensation for the loss of the use of water and hot water
Right.
during that time period. Is that something you want to put to a vote? I mean,
I will put it forward as a motion.
okay. Is there a second?
I second it.
Okay. All right. Any discussion?
No,
Hearing none. All those in favor of awarding Ms. Crewy $200 for compensation for her claim? All in favor?
aye.
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 The ayes have it. Pass unanimous 3-0. With regard to the payment terms and conditions, I'm going to add to it as part of my own motion that concierge be directed within 30 days of this hearing date to make payment to the town of Rocky Hill and send it to the finance director, at which time finance director will turn around and cut a check to Ms. Curry at her new address for the amount of $200. Do I hear a second on that motion?
Second.
Okay, all in favor?
Aye.
Aye. The ayes have it, 3-0. Thank you very much, everybody. Okay, the next claim is,
Is that an extra or?
I think that was, yeah, that was given to us by, yeah, it's an extra. Mr. Charlesberger, I appreciate your time and patience. Thank you for indulging council's request to switch the order. All right, so with that in mind, you've heard the
I get
rules
the
and regs. We're
Yes.
gonna swear you in.
Okay.
Raise your right hand and state your name and address for the record.
Joshua Strasburger, 300 Cold Spring Road, apartment 604, Rocky Hill, Connecticut, 06067.
Do you swear or affirm, whatever the case may be, that the testimony you give tonight is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. All right, Mr. Strasburger, you are one of the only complaints today that you still live in the apartments at concierge, correct?
Correct.
All right, so that changes how we may address it. So if I understand correctly, you filed a complaint back in March 2023 because of a rental increase from what you were currently paying then as $15.56 to $17.19. Is that correct?
Correct. There were additional things. Initial lease, they charged more than the agreed upon rate, and that kind of carried over to the second lease and eventually carried over to the third lease.
Okay. So getting in a little bit more detail is that you had signed the lease back in March 2021, and that seems to be your anniversary date. But when you first signed your lease in March 2021, you did a 14-month lease.
Correct.
Okay, so
And
that would be, then assume that your next renewal date would be in
May.
June,
Or
end of May,
end of May.
beginning of June.
And the second lease has a date of like data being filled out, of May 25th, 2022.
Okay.
The email for the 12-month extension was May 26th. The data was signed May 26th. However, they stated the start date as March 23rd, so 2 months after the fact.
So you didn't get the benefit of the lower rent that you would have had as a result of the remaining 2 months on your initial 14-month lease?
Correct.
Okay. And that's part of your claim today?
Correct.
Okay. And then you have additional reports of being overcharged the term of 3 years. And those overcharges are with respect to, I'm assuming, late payments or various charges that didn't reflect the terms of your lease.
Correct. So initially it was terms of lease, either the monthly rate, so $12.49, they're charging $13.65. I've requested a copy of what they have on file. They've told me they don't have any copies. I've requested documentation on how that $13.65 was determined. I have never received any confirmation for that.
What was that $13.65 again for?
For lease one. However, I have no idea where that number came from. So they were charging me $13.65. I was paying $13.65, but I agreed to $12.49.
Okay.
And then with lease two approaching, I had two primary complaints. The first one was I had been overcharged. I kind of wanted that back. Second aspect was that it was a 24.6% increase. I used 3 different methodologies to determine what it should be. I used minutes saying a 7% increase from last year from this committee. Minutes saying it should be $1.49 per square foot. I used their price increase on a comparable unit. I'd like to add a fourth. The second gentleman who testified said that his rent was $15.91. I believe it was stated that on average, a 2-bedroom is about $200 to $300 more than a 1-bedroom. Assuming $250, I live in a 1-bedroom, just for clarification, that would make a $15.91 minus $250 equal $13.41. And so all 4 numbers kind of merge on that $1,340 a month. So as this lease has already expired, I still wish for that to be some consideration.
Okay, are you currently under a written lease right now? Or are you month to month?
Currently, no. It's the 17-19 lease. However, I have been paying $14.83 based off of the recommendation of the, I forgot which court it was, for how to proceed during, like, waiting up to a Fair Rent Commission meeting. And it's basically stated, pay what you deem to be appropriate and fair.
Okay.
I went through how that number was determined. If you guys have questions, I could try to explain that a little more. But.
Well, if I could stop you there.
Okay.
I got, and I'm going to turn to counsel to my left for additional guidance. But I would say first I want to state that it appears that your approach, at least with respect to comparables, is commendable. It's not something that's often done at fair rent hearings in terms of determining whether that rent is under the standard of harsh and unconscionable in terms of doing comparables. So I applaud you for that. However, you may have heard, if you're present during Mr. Boney's hearing, or Sony's, that I think the bulk of your claim, aside from the rental increase from $15.56 or to $7.19, whatever the number, but up to $17.19, the bulk of the rest of your claim, if not all the rest of your claim, appears that's outside the authority and scope of this hearing, outside the authority of this commission, and outside the scope of what we're supposed to determine. It seems to be more of a situation that would be something that you would file in a municipal or superior court, particularly housing court. I can't really give you advice on what to do, but we're determining. I told you at the top of the the beginning of this hearing is that We determine if rent is harsh and unconscionable, and we'll lift, there's 13 factors that I've stated support such a finding or determination. In addition, we look at safety code violations or health issues. But we have a limited jurisdiction to focus on that. I'm not saying and commenting one way or the other whether you have valid claims in that regard. I just don't feel that that's something that our commission has the authority to provide.
You.
And I'm just going to turn now to legal counsel for the town and ask for guidance if am I correct in my understanding of that?
Yeah, my view is the same as was earlier. As I understand the first claim, it really sounds like more of along the lines of a breach of contract claim, that there was an agreement at a number, and then they charged me a different number, and I should be reimbursed. This commission is to determine if rent was fair, it was, was harsh and unconscionable under the standards. You did that. If this particular witness showed at that window of time that the amount that they were charging was, harsh and unconscionable, you could have make an adjustment back then. But it seems from the witness's testimony and the package that the reimbursement component is really a breach of contract dispute as opposed to what the rent should be.
May I ask two questions?
Absolutely.
First one, just because of the duration deviation. The argument began in March or in or what the rent for the third lease is? Because part of my argument is one lease was 12, so it should have been 14.
So,
do you want my second question first?
no, I understand what you're saying is because when did if we find merit to your claim, when do you start to allocate that award?
Exactly.
You moved in March 2021.
Correct.
And did you provide a copy of that 14-month lease to us?
Provided my application, offer to rent, excess of conditions, and price. No one has a copy of my lease. I've requested. They have zero on file.
So when you're saying no one has a copy of the lease, are you
sorry.
So
there is documentation regarding the start date, end date, price, location, duration, all that. There is not a traditional lease, that 7-page document.
Yeah, so
it kind of meets the Connecticut requirement of a lease, however, it's not the standard lease.
okay, but the lease, did you or I'm only focusing on 2021. We're going back in time.
Yes.
But in March 2021, is it your testimony that you moved into this apartment without a written lease?
I without a finalized lease. There were the agreements, but no. So there was the application for 14 months, start, end date, price. There was the offer to rent, start, end date, price, and location of unit. The security deposit, which is under their documents called the application approved charge. So assuming they approved those 3 metrics. And after that, they would not provide me a lease.
Okay, we'll say they wouldn't provide it because it didn't exist.
Yeah,
Like you didn't,
presumably.
in other words, what I'm saying is you didn't sign a lease, they didn't sign a lease and give you a copy where you had a fully executed lease for the term of 14 months. Is that correct?
Correct, in the traditional lease sense.
Okay, so there are other leases out there outside of a written lease. I mean, you can have an oral month-to-month lease based on the course of conduct and how your payments are going in. So in this case, is it accurate that if you were operating without a fully executed written lease, you still had a lease with them and it was oral? Is that correct?
Correct. So
Okay,
between month 12 and 13, there was no change in rent.
Okay, but not to get, this is the lawyer in me.
I know, I'm trying to be direct, but.
But if you're talking about that there was a promise to
Yes.
pay that you had 14 months, I think your issue would be that it would be, and that there was a certain promise over the course, that your rent would be for the course of 14 months at a stated price. Without a written lease, correct me if I'm wrong, there would be a violation of the statute of frauds that would require any agreement greater than a year that can't be performed within a year in writing. So I don't know your claim, based on your testimony, hold beyond a year. So what happens is you are essentially defaulted into a month-to-month lease in which you were paying whatever you were paying up until that time. So I think that disposes of whether there be 2 months or whatever months. But at a certain point in March 2022, am I understanding that you finally had a written, fully executed lease?
May 2022.
Okay, so May 2022. So that's going to be my start point. So you had a lease from May 2022 that took you up to May 2023, or the end of April.
The lease was created in May 2022.
What's the term of the lease?
It retroactively applied to March 2022.
Okay, and that's fine. But that's a lease that you signed.
Correct.
Okay.
And I try to get, notify them of the issues, no response, but yes.
But in any event, you signed a lease that recognized that you had a lease term dating back from March 2022 through to the end of February 2023, correct?
Correct.
Okay.
Wait.
What was the
March to March.
March to March? Yeah, okay. I don't know if it's in the middle of the day or if it's March 1st and ending on February 28th or 29th. So, but we're on the same page. So then comes March 2023.
Correct.
What was the lease that you signed in March 2023?
It's for March to March.
Okay. What was the amount of the lease?
It was 1719 plus they included now waste and trash, which is 35, so 1745 effectively.
Okay. And you signed that lease in March 2023, correct? And it's going to expire in March of 2024,
yes.
Correct?
Correct.
All right.
Now, to make it, I was told in May that my lease, second lease, should have been valid till May, which doesn't help this discussion at all.
Yeah, I'm trying to narrow the issues for you, for the other side. I'm sorry.
I understood.
I'm leaning in on you, but I'm trying to parse this down. But your claim, the other issues in terms of overcharges, stuff, whatnot, that's not within our purview. Number two, in terms to answer your question, we eventually arrive there. What date does it start? Right now, I could say that if there's an issue, it would start in March 2023. And if I can understand your question, your issue now is whether the lease that you signed where you agreed to 1719 plus the waste, which takes it up to 1749, the waste charges, whether those charges are harsh and unconscionable now because you've done a comparable analysis on current rental units that are being offered for lease within concierge. Am I correct on that?
Correct.
Okay.
May I
Do you have any questions? Yeah, I'll let you. Just any questions up at this point? So
There's a lot of information. So
okay. Do you have anything else to present?
the only other aspect was I wanted to move out of concierge for various reasons. No one would notify me if my lease ended in March or May. And the other places I were looking at was less than the 1483. I was curious if that could be put into consideration. If not, I understand.
Yeah, so I mean, if you're currently looking to move out of the apartment, again, outside of our purview, but I'll just give you some friendly advice. Look at your lease. It'll tell you if you penalties for breaking the lease. It'll tell you the term of the lease. That's why it's in writing. And I don't mean to be harsh or flippant. I wouldn't even address it because it's not a claim. But if you're looking for guidance on that, what better proof than to look into the lease itself? The comparables that you did are based on what you've seen on the website or what they're offering for lease within concierge, correct?
Correct.
And you're comparing one bedroom, one bath units just like your own.
900 square feet. The closest comparison is B604, my unit, same floor, one building over.
And it's for less rent.
$1,480 total.
Do you know if what it's being offered for that lower rent is because it's being offered for a 14-month lease as an introductory price?
There is no discount stated for, and they've had the like blowout rates, and then you hover over it, and it's from like June 2010 through like December 2045.
Do you know if any of your research revealed whether there was any other rental units renting higher than your unit? And I mean, it could be whether they were current tenants or it's being offered currently.
No, and so for comparison, on my floor, at the same time when I was looking at my renewal, there was a 2-bedroom, 1,360 square feet, so 50% larger, and it had a base rent price that was less than mine.
Okay.
So just to give a scale of how excessive it had become. Also, at one point, my unit was on the website. I wish I took a snapshot of it, but it was a few $100s less base rate. So.
Okay.
I have a question. While you were doing your research, and we're trying to get a new lease, did you bring the disparities to the attention of concierge?
I did. So I sent it both internally to their like main office, and I was told, through the internal communication system, I was told that they do not deal with local matters. I gave the information to the leasing office. For all information I've requested or provided, I've never received a response that I'm aware of. So they have that information. I also provided my complaint like a month and a half ago, the full thing. So they had it in March, and yeah.
The complaint, you're talking about the complaint for this hearing.
Yeah, so the complaint for the hearing I provided at the end of September, beginning of October. But the comparables I provided in March,
Okay. Anybody else have any questions? At this time, I'm going to turn it over. It may ask you to stay where you are, depending on what Concierge's Council has, but they may have some questions that they want to ask you indirectly through us, if you could. Counselor?
Mr. Strasburger, so the current lease you have is for 1719, correct?
Correct.
And the prior lease to that was for 1556, correct?
Correct.
And the increase between those two, I'm doing some rough math in my head, about 11%, give or take?
Correct.
Okay. And you signed that lease in January of the current lease in January of 2023, correct?
I believe it was later.
Okay.
I believe it was March, because
Okay.
I was trying to move out and have them confirm when the lease ends.
Okay. But you did ultimately sign the lease?
Correct.
And you signed the prior lease for 1556, correct?
Correct.
Okay. I have no further questions for this witness.
Okay. Mr. Strasburg, we're going to now turn, unless you have anything in rebuttal you want to say or any statements.
Only statement is that I know you're looking at a percentage aspect. I think I provided adequate information on truly comparable. I pulled up today, this morning, my unit, the next one available, base rent price is $1,270. It's $260 less than mine is. We're almost a year past. I do not believe housing prices went down. If that is the case, please let me know. But yeah, I think I provided adequate information that 1719 is beyond excessive.
Yeah.
Thank you
Okay.
very much.
I want to ask you if you could step down, and then I'll turn to Concierge Council to present their case.
Absolutely. Taking advantage of the 5-page rule, I would like to submit copies of the cover pages only of the current lease, the prior lease, and a copy of the offer to rent that was made in 2021 when he first moved in. So it would be the initial amount, the next renewal, and then the current renewal we're in. So I have a couple copies. I'll give one to the witness, and I got a couple more that I can hand up
Okay.
here.
What is that?
It's okay.
You guys,
We
you want
can
me to-
share.
Here, you want me to share it, Marty?
Yeah.
So these are just the cover pages, but they do identify what the rental amounts are, as well as in the the 2022 lease clearly identifies in the bottom, I believe, right-hand corner, or at least that bottom quadrant, the end date of the lease. So very clear. These are documents that are available as part of the system and easily could have, I don't know why the claimant does not have a copy of this. I would also like to point to the documents we submitted on December 4th, which show the rental charges as part of the ledger for Mr. Strasburger over the last couple of years. They clearly identify that throughout the 2021 lease, he was being charged $1,224 per month in rental charges, and no more than that. There are additional fees that are associated with it, but that was the total rental charge. And you can see it in every single month for the portion of that lease as part of the ledger from our December 4th filing. And then I would also like to bring up the discussion that was had in the July hearing about rental increase percentages, and I believe it was discussed at that hearing that 15% is not, out of the norm these days. And I would point out that the rental increase between the 1556 and the 1719 exactly comes out to 10.5%. So lower than the 15% that we had discussed in the July hearing. Now, I understand Mr. Strasburger wasn't here for that, but it was a general discussion about rental price increases and what was reasonable or not. And again, I would refer back to the ledger to show exactly what he was charged in rent throughout those periods. And I would point out that there is I understand I'm the lawyer here and I can't really give testimony, but I would point to there's a reason that empty apartments are offered at a lower amount, and it's because they're empty. And the landlord wants to fill them. And the idea would be that over time, as you renew your lease, there is a percentage increase. And that's exactly what has happened here. If the tenant wishes to live somewhere else because they believe they can get a better rate at another apartment, that is absolutely their right. Again, the terms of the lease are laid out very clearly, as well as the lease end date. So that's all we really have to say for this one.
Okay. Yes, you're going to pose it, ask you to step up to the mic, Mr. Strasberg, and ask questions. Now, understand this. There's some limitations. He's not a witness, but you can pose questions. He does also represent concierge.
So you mentioned that my rent for 2021 was how much?
$1,225 according to
And
the
you
ledger.
mentioned that my rent for 2023 is how much?
My understanding is you were increased to $1,317 for a period, then you were increased to $1,475.
And would you like to provide information on what other fees I have? Because there's
Absolutely.
$1,475 plus CAM.
Right. So CAM is common area maintenance fees. That is regularly charged in a lease to account for the common areas and how those are charged for. There is also a global fee of $17 per month.
Is that in my lease?
Yes, all of these are laid out in the lease. That was part of your, if you go through the lease, all of these are laid out in there.
Could you
It would
provide?
take me a minute to find all of them, but they are all in there. And I can also point to, there's a trash fee of $7 per month, a pest control fee of, I believe, $4 per month, a gym fee of $50 per month. I think that's it as far as the additional fees go. And again, this is all in a ledger that was provided.
Understood. Because it says base rate, and the base rate is the sum of all of those fees minus CAM minus PET. And so there's nowhere in the lease that mentions the carpet fee, the floor fee, global amenity fee. So if you could please provide that information, that'd be great. Otherwise, it sounds like you're arguing that my rent should be $1,475 plus $114.
Again, the current lease is for $1,719 that you signed earlier this year.
So now my rent is 1719, but my rent in 2021 was 1225.
Plus the additional charges, correct?
So it wasn't 1225.
No, your rent was $1,225, and there were additional charges.
Okay. And my rent now is,
My understanding, so the actual number that you are being charged in rent on a monthly basis is, hold on one second.
my
1,000.
point
Wasn't
is
it
that-
1719? Just really shortcut this.
Yeah, no, so my point
1719
is that
plus $30.
he's comparing apples and oranges, saying that I wasn't being charged $1365, I was being charged $1225. The fact of the matter is, I was being charged $1365 because, as he said, the 1719 is the sum of all those numbers. I would just like for clarification in 2021 in Union, what was I paying per month for rent?
If I am to up the charges, give me one second to do some quick math. 50, 80, 25, say that's 100. 1360, give or take.
$1365. What was my offered rent?
Your offer to rent was, I believe, $1,251 plus additional charges.
Okay, just want to confirm that you have that on file, that those are two different numbers.
Right, it's
Okay.
$1,251 plus additional charges, which comes out to $1,360
But-
something.
And you cannot, there's nowhere in the lease that mentions any of those numbers.
They are all in the lease. Again, the CAM fee, the trash fee, the pest control fee.
There's, so, when you look at the total price, this is what I'm trying to get at.
I think, Ms. Strasburg, I understand your issue, but you, again, going back to what we said, you're arguing issues what should or shouldn't have been in 2021,
No, so
2022.
I apologize. So my point is, I don't want to come across as, when I say that a unit now is for $1,270, that you guys got the impression it's $1,270 plus pest fees, plus all those other fees. It's $1,270 plus CAM. That's it.
I understand your claim.
Okay.
There's a
Just
delta.
wanted to confirm.
There's definitely a delta in terms of what's being offered. Your testimony's been what's being offered for a similar unit of size and location within concierge than what you're currently signed on for under your current lease. Okay.
All right, thank you very much.
All right.
I would also like to just point out briefly that the lease that's in this packet is not the complete lease. There are a number of addendums that are not part of this, that are part of this lease that are not included
You're
here.
pointing it to, are you pointing to his?
To the packet that was provided to us
Okay,
from the
understood.
commission here.
Understood. Okay. All right. Anything else from both parties? That's it?
That's it.
All right, well, we're going to, Mr. Strasburg,
I'm just curious, can there any confirmation that you have?
the microphone, please.
Sorry, I'll let it go.
Okay. All right, we're going to close the evidence portion of the hearing and go straight to deliberations. It's late, but we will consider it. If I understood correctly, so if we can focus this, is that in this particular situation, we are not going to consider charges and whether it was a 14-month lease or not in 2021. It's just outside the purview of this commission. They're more akin to, say, breach of contract claims or claims that you would have a landlord-tenant court, which is not us. Focus, again, based on the testimony, I don't think it's disputed, that the lease, if there was an award, it would relate to the date that it could potentially relate to the earliest date in which he signed the lease for, the beginning of the term, which is March 2023, regardless of when he signed it. But we know that it dates back to there, that's the term of the lease, because it will expire in March 2024. So, that being said, my thoughts on this, unless, Marty, you want to take this one, or?
No, go ahead.
All right.
You're doing well.
I applaud Mr. Strasburg. He's the first one that actually did comparables, which I want people to do because that's definitely a criteria that helps guide this commission on doing what they, to make their determination. So they're looking at like-kind properties, rentals in the relevant community, and that's what we're supposed to do. However, I don't see this rental increase as being harsh and unconscionable. I don't think that the evidence presented addresses it. I do see that Mr. Strasburg, very organized in his presentation, but he did sign a lease in March 2023 for this rent. I think there's some buyer's remorse there. I've done it a few times too, and we all probably have, but knowing that other people are getting different deals, but there's also other reasons for that. But I don't see the factors in support of a harsh and unconscionable finding of excessive rent, particularly under those circumstances, but also in the fact that the evidence presented doesn't seem to support it, and as council points out, it's a little bit more than 10% of rental increase from year to year. So those are my thoughts.
Okay, and I would agree with you there. We've looked at the marketplace, not only here in Rocky Hill, but universally across the country. And the standard is the median standard of increase for existing increase in rent, meaning that you've gone beyond the threshold of renting an apartment maybe at a lower rate because the landlord had empty apartments, okay, and was looking to fill them and was willing to take a loss in the first year. But they're going to make it up. They're going to make it up as you go along because they have expenses. As you heard earlier, you know.
It's incentivizing people to get in the door and sign
Right,
leases.
okay, and they have expenses, okay, meaning, you know, what was it, the boiler broke down, okay, and they had to spend $10,000 to, you know, to buy a new boiler, okay? That doesn't come free, okay? It gets added on to, you know, proportionately to everybody's rent, including the expenses that come up.
Okay.
I think that, in all fairness, you know, we've got to look at what is fair and what is unconscionable.
Understood.
Okay, so,
I agree. I agree wholeheartedly.
I also agree.
Okay.
Makes,
So I guess first and foremost, which I think would address it, is whether we have a vote or whether there's a finding, whether it's Mr. Strasburg has carried his burden, and whether we believe an award in his favor is appropriate or not. So I would ask for a motion as to whether you think an award is appropriate or not. I guess you'd have to say it is like, is it in favor of concierge, or we make a ruling in favor of Mr. Strasburg, in which case that might
I would
depend.
go with the increase falls within the parameters that we have researched,
I agree.
okay? And therefore, I would have to say that he was presented with a rent increase, okay? And he knowingly signed the rent increase and agreed with it at that point in time. So
Okay,
therefore,
along those lines, do I hear a motion with regard to, a motion for finding
finding
in favor of concierge?
concierge.
Okay,
yes.
is there a
I
second?
it.
Okay. And just to clarify for the record, it's a finding in favor of concierge, meaning that no award shall be granted to Mr. Strasburg, correct?
Correct.
Okay. Any further discussion? Hearing none. All those in favor?
Aye.
Aye. The ayes have it, 3-0. Thank you both. Appreciate your time.
Can I request that 15% data? Because I had 15% over 2 years, and my rent increase was 24% over 2 years.
I don't think that we're at that part of the hearing where we can act in that agency, what it says.
I was curious if there's like historic, like.
The one thing I would just say is we have very tight constraints in terms of our authority here, and it's not a rent control situation where we can do that. So that being said, we're going to make a motion to close the hearing.
No, we have to
Oh, what?
vote
well-
now.
You want to do that now?
Okay.
You need a motion.
Okay, sorry. Well, we have one other thing. Oh, this is, it doesn't necessarily require, this is more of a,
Establishing the regular meeting.
okay, we have a regular meeting schedule that has been provided to us by the town, and it sets forth, you folks may want to hear this, We have for the 2024, to the extent that you're involved in any, which I believe you may be. Okay, so we have meeting dates that will fall on Mondays. I believe they're, for the most part, the first or second Monday of the month, but starting in January 8th, February 12th, so forth, so on, all the way up through December 9th. There are a couple of Tuesday dates. You can get a copy of this. I'm sure it's going to be posted on the website. They also have corresponding application deadlines that are to the tenant, so if anybody's making an application for a fair rent complaint, there are certain requirements if you want it to get onto that agenda at the earliest on the agenda, because it always doesn't happen necessarily that way. There's application deadlines. This will put a notice out to everybody, all parties concerned. Going to be something that's on the website, so I entertain a motion to approve this meeting schedule as final for 2024.
Okay.
All right.
Second, okay, second, we got a second?
I'll second it, yeah.
Second, and Marty
Yeah.
was the first. Okay, all in favor? Aye. Okay, it's approved unanimous 3-0. Thank you very much for everybody's time and patience. Thank you.